Join the meeting. Good
Good
morning.
morning, Anna.
How are you?
I'm doing well, thanks. How about you?
I'm well, thank you.
Good.
Mhm. So you sound good? No echo, nothing.
Oh, okay. Let's hope it stays that way.
Yeah.
You folks have been keeping busy.
Yes. How do you feel about going back to in-person hearings?
Oh, I think there's a lot of benefit to the in-person hearings, just the dynamics and being able to confer with people and the dialogue amongst the individuals. I think it's a plus.
Hmm.
Can you guys hear me? Hello? You can hear me now? All right, good. All right, cool. I just wanted to make sure.
And David, this is Jeff Albright. Can you hear me okay? Mr. Lee?
Yes, I can.
Okay, great. Thanks, David.
I heard a feedback from both of you.
Do you hear echo from me? I do
Yes.
hear it. I'll log off and log back on. Do you still hear an echo?
No,
Thank you.
thanks.
I know. Yeah.
Sydney, your audio is on.
Okay, I'm gonna close my, but I'm not because of you guys, just I don't want to bother you guys with my audio.
All right, Mr. Lee, are you ready? Good morning, Mr. Lee.
Yes, sir. Good morning.
Thank you, sir. Okay, good morning. This is the September 2nd edition of our hearing in this matter regarding PNM's application for approval of abandonment and securitization or financing order from the commission, case number 21-00017 UT. My name is Anthony Medeiros, as you all know. We need to get ready, but why I'm stalling is because I'm hearing that dreadful delay. I've been calling it an echo, but it's more apt or more accurate to call it a delay. So if anybody out there is doing the dual streaming, please stop. It has not stopped yet. And let me emphasize again, after just a little while, it becomes very hard for me to listen to it. Imagine being our excellent court reporter trying to take this. It becomes untenable. So, again, I still hear it. There has to be somebody out there because we have nipped this in about a couple of times, but it keeps growing back. And I'm not going to continue until we figure it out. Mr. Lee, are you hearing that echo or is it just me?
I can hear it.
I call it an echo, but it's a time lapse. I think these Zoom hearings are hard enough on all of us, particularly the witnesses and counsel trying to put on their cases and focus on the cases being presented, those other counsel, that it's difficult enough in any event. So I'm hearing myself speak still.
Your Honor,
Mr.
Ms. Sanchez's box is lighting up while you're speaking. Let me go into the next room and see if we have somehow two audio feeds on and if we can correct that.
Well, it must be that. Thank you. Thank you, Mr. Gifford. And while Mr. Gifford's, well, he should hear this, but it was his count. It was Mr. Buffington who responded to a question about properly marked exhibits in the record. Is there any question about that still? About whether it was in an email to me, and basically the question is, what is properly marked? PNM's exhibits are properly marked. Just require a simple header or footer. I think theirs is a header on the left-hand side for properly marked exhibits, Mr. Gifford. Mr. Lee had a question about that, being very careful to protect the record. He was only going to attach properly marked exhibits. And yes, PNM's exhibits are properly marked. They just simply require what PNM and NAE subsequently did in putting a header or footer on the document, on at least the very first page. It'd be ideal to do more like Sierra Club did yesterday. You noticed that the cross Mr. Gerhardt did went, there was no going back and forth in the document because Mr. Gerhardt said it's SC Exhibit X on page 39 of 87. And so that's ideal because then you're right there at the page. But to the extent that's not happening, at the very least, I plead that you put the exhibit number on the first page. So are there any questions around exhibits? Okay. As promised, I indicated that the first order of business today would be to take care of the disputed issue of administrative notice of the disputed portions of the record from the merger proceeding, the Avangrid Iberdrola PNM merger proceeding case number 20-00222-UT. We have 3 disputed portions remaining. New Energy Exhibit 13 and a portion of New Energy Exhibit 16, and those are pages 196 and 255 through 56 of the transcript of the testimony of one of the joint applicants exhibits, joint applicants witnesses in that case. Is that accurate, Ms. Nazi, in terms of what we have remaining in dispute?
Good morning. Yes, it is, sir.
And Mr. Gifford, thank you for fixing that time lapse. Mr. Gifford, I'll hear from PNM on its objection to these 3 documents.
Very quickly, Your Honor, we had come to an agreement with Sierra Club and attempted to come to an agreement with Ms. Nanazi as well on those items. We agreed with Sierra Club on all the items. These are the outstanding 3 issues. We simply don't think they are relevant to this case is the short and the long of it, and do not belong in this record.
All right. Ms. Nazi?
Yes, thank you. I believe that a number of witnesses, including Ms. Sanchez, have denied that the merger was a driving force of this particular abandonment application. And I believe that there's a couple of things that are in these documents. That one is, it's very interesting around the timing. Many of the admissions, I'll say, that were agreed to with Sierra Club and are included here happened before Your Honor's order in June. Not completely everything. The CCAE response by Mr. Azagra Velasquez is particularly important because he goes into that, yes, in fact, it's a contingency, and this is why. And then the other two issues are that Mr. Azagra Velasquez says we do have an ESG policy that won't allow coal, which I think is important. And then the other thing is that he admits at the end that in his opinion, that the Four Corners divestiture is a cost of the merger. So I think those are relevant, important for the commission to have a full record. And we're talking about essentially 5 pages.
And we're talking about objections on the grounds of relevancy. And again, order after order after order on evidentiary issues have emphasized that under the relaxed rules of the commission's relaxed rules of evidence that the hearing examiners apply and should be trusted with applying at this late date. I don't see a particular problem in allowing these 2 exhibits into the record. They have been properly submitted for administrative notice. Mark that, Ms. Nanazi. I noticed that you know how to use the doctrine and the rule.
I have people.
And this is the right way. Well, I know, because there aren't enough hours in the day, right?
Nope.
Because one would not want to be flouting the hearing examiner's orders, right?
Correct.
Particularly when the objection is that there aren't enough hours in the day. In any event, that's for a future attraction. So because Ms. Nanazi, to be quite blunt, we still have an issue out there with administrative notice and query whether it's been applied on the other issue. It has been here. So it does demonstrate that the movement knows how to use the rule, at least. So that being the case, NEE Exhibit 13 and NEE 16 are admitted. And they will be given the weight. I don't know how important they are, if they are important at all, or quite frankly, if they're even relevant, because I indicated with regard to the objection that Mr. German made on the first day, PNM doesn't need to make that rolling objection anymore because I'm taking that matter under advisement. I want to see the briefs on that. So I have not ruled that that issue is relevant, but those documents will come in and they will be given the weight that they are due. All right, what other, I'm sorry.
I'm sorry, Your Honor. For clarity, we're talking about what Ms. Nanazi described as the 5 pages that are at issue. Is that correct?
For the objection, Mr. Gifford?
Yes.
We're talking about, well, there are apparently 2 issues. One regarding merger costs, Ms. Nanazi, right?
Correct. It's New Energy Economy Exhibit 16 and 13. And
right, but there are 2.
Sorry. It's the same as
go ahead,
Sierra Club's 8, and I could withdraw if you don't want to. But one had 8 plus disputed and 8 and not disputed. So now if Your Honor has consistent with your ruling, then it would be Sierra Club Exhibit 8.
And yeah, let's not unnecessarily monkey around with the Dropbox folder. It's okay. I'll tolerate this level of duplication now that we've got the documents sorted out.
Thank you so much.
So, but going back to Mr. Gifford, I believe the issue is that the merger as the driving force for the abandonment. That's one. And then there's something else that I don't entirely understand, but it goes to, which is a statement, not an accidental statement, but that I don't entirely understand about merger costs that I imagine I might be enlightened in the briefs on how that might be applicable.
Understood. Thank you, Your Honor.
Thank you, sir. All right, are there any other preliminary matters before we get back to Ms. Sanchez's cross-examination, this time by the Attorney General, I believe?
Yeah, one issue, this is Kyle Tisdale with Community Groups, Mr. Hearing Examiner.
Yes, sir. Good morning.
Yes. Good morning. PNM has been able to make available the NTAC operating agreement that was at issue earlier with Mr. Falgren's testimony. And I've had the opportunity to review that. And I move for your reconsideration of striking the testimony of Mr. Falgren relative to that operating agreement. The portions that were questioned about with Mr. Falgren remain completely unchanged and identical between the two operating agreements. And this is in particular with respect to the definition language for management committee and member representative groups. And so those portions that I questioned Mr. Falgren on remain unchanged. And so even if you are maintaining your ruling that that's not appropriate for that exhibit to be admitted, I do believe that the testimony should remain unstricken.
You know?
Well, Your Honor, we would stand by our objection that Mr. Tisdale didn't use the operating agreement and therefore doesn't get to use an old, outdated document to ask our witness questions. As to the admission of the document, if Your Honor is inclined to allow it in, we would ask that the new document also be allowed in so we can understand how this new operating agreement works, and if the definitions have changed in the operating agreement, inform the hearing examiner of what that might be. We haven't had time to do the complete comparison of the documents.
We're on a very short time frame on, I appreciate, I'm not responding, Mr. Gifford, to your objection. I'm just saying that the issue, but I'd imagine the way that this would have been presented, quite frankly, and I feel like I'm at the National Judicial College trying to instruct folks on stuff that they should know, which is that you take the document to the opponent and you say, this is the document, how can we work this out? That apparently was not done, so I'm going to move on from this issue. The reconsideration is denied. We got way too much to get to. Reconsideration denied, Mr. Tisdale. Thank you. So, and that issue, partly why I mentioned, sometimes I gas on, and I try not to. I try and be more circumspect in what I say, but I need to try and emphasize once more that with regard to these issues over which documents are in the record and administrative notice. For instance, on the issue of administrative notice, you don't want to just put anything that you purport to be something in the record and then have it come back to bite you because there's something in that document that ultimately hurts your position or that puts something that contaminates your position in the record. I'll expand on this a little later because we have a very serious issue still to sort out with regard to 16276. But I'm gravely concerned that some people don't quite get the problem with having certain documents in the record. Here's one that goes back, it's a classic law school example. the learned treaties, like Moran's, there are certain treaties that, like on the cost of capital, for instance, that often get introduced in rate proceeding. You don't ask for administrative notice taken of all, however many chapters of the book. You ask for a particular passage that is relevant to the matter. There's a heck of a lot of obvious extraneous stuff, even in the most learned treaties. And so we don't want those things potentially contaminating the record, particularly when, while the esteemed scholar may say something great on your position in one regard, in another regard, it may gut you. So please bear in mind, these rules have application. They are developed for a reason. And sometimes unintended consequences can come back to bite you. And I fear that they may come back to bite some parties here. So with that, let's move forward with the Attorney General, Mr. Elliott. I have you down for 50 minutes with Ms. Sanchez, and you took 39 minutes with Mr. Falgren. How do you want to address the issue of the remaining balance of time on your witnesses?
I am hoping to use less than my allotted time with Ms. Sanchez. And in that regard, I'm putting off an explicit answer to your question, Mr. Hearing Examiner, in hopes that I'll have.
Okay. Well, I could show you on share screen what my running tally looks like, but right now I have you with 50 with Ms. Sanchez, 10 with Mr. Phillips, and 23 each with Graves and Eden. And the reason I've done that is I've just reduced the time.
Graves and
Graves, G-R-A-D-S, and Eden, E-D-E-N. Sorry, Mr. Lee. And I just, for now, that's not, you're not committed to that, but that's just what I've done is I just take it commensurately from each witness, if that makes sense.
Absolutely. Thank you.
Thank you, sir. You may proceed with Ms. Sanchez. You have 50 minutes.
Good morning, Ms. Sanchez.
Good morning.
Also, Mr. Elliott, before you begin, I'm sorry, I need to say one more thing because hopefully it'll streamline things. I had a couple of questionable, one improper objection from counsel who are not sponsoring the witness, particularly in the relation of, again, going to the weight, hearsay. I have another sanction short of cutting time, but it's in my discretion which one I want to use. And that is that I will mute the objector who made an improper objection. If that doesn't work because the objector tries to unmute himself or herself, I'll have that party banished from the Zoom hearing temporarily. Goes back to the old, and because, anyway, hopefully we won't have to go there, but that's a sanction short of or in lieu of cutting time, although time is coin of the realm and I'm still inclined to cut time. So again, bear that in mind, particularly when also on top of that, you don't identify yourself in making the objection and I have to ask who's that. So again, I'm trying to get us streamlined and going in a quicker direction today. So those are the things that I saw yesterday too. So Mr. Elliott, your 50 starts when you're ready.
Thank you. Good morning, Ms. Sanchez.
Good morning, Mr. Elliott.
I believe this is the first time I've had the pleasure to meet you. Unfortunately, it's through Zoom. So I have some questions regarding just your background as the Chief Policy and Legal Advisor to PNMR. So starting with your direct testimony, page 5, you say that you're responsible for oversight, development, and implementation of regulatory policies and strategy that support PNMR's overall operational strategy and functions. My first question is PMR located in the same building as PNM?
It is.
Just by way of some of your background, could you identify some of the regulatory policies you're responsible for overseeing?
Sure. I have, most of what I've worked on has been in the context of recent regulatory filings. So just sort of going back to when I first started, and I joined actually my very first day at PNM was the first day of the San Juan case. So I had done a little bit of work prior to that, just preparing, but I did work on that particular case just in terms of following along, but also reviewing documents, basic stuff to get up to speed, also assisting in general in, as you can imagine, a lot of that work as attorneys we do in groups, right? We sort of, talk about the strategy of various things. So I was involved in some of those discussions. I'm also a part of the policy department. So we have a number of different groups under that, or within, I should say, the policy, public policy department of regulatory, government affairs, public affairs. One of the other big projects that I've worked on is grid mod. So I've been working on an internal process with.
Sorry, one other project I'm working on.
Yes, is grid mod, and I should say the full grid modernization. There was a bill that passed in the 2020 session on grid modernization, and so one of my projects is working on developing the internal stakeholder process and the external stakeholder process for grid modernization in preparation for a filing at some point.
Are you familiar with MNERD's policy papers on grid modernization?
Is that another acronym?
Yes.
Energy, Minerals, and Natural Resources Department. I'm sorry, you said yes?
Yes, I am familiar with that.
Are they one of your stakeholders?
Absolutely. They're a very important stakeholder.
So do you work with Mr. Fenton? Does he report to you?
He does not report to me. He reports to my boss. I work very closely with Mr. Fenton on a variety of things, yes.
And you report to the VP of the senior VP for public policy. Is that Mr. Darnell?
That is Mr. Darnell, yes.
Okay. And he testified in the 19-0018 case, right?
Yes, he did.
But he's not testifying in this one.
No.
Why is that?
I'm not sure why he is not, but as you can imagine, we have multiple cases going on right now, and he was very busy with a merger case, which he was a witness in. Okay.
And you mentioned some of the other departments that you work with. You said government affairs, so is that like, is that lobbying? Is that you engage with the legislature?
The government affairs and it's government and public affairs. So government affairs and public affairs are under that umbrella, and they do interact with the legislature, but they also do other community-based work, and they work with the foundation.
And so does the public affairs, is that, do they help organize media buys and communications externally?
No, that would be the communications department, which is also under public policy.
So would they help with, say, the marketing for the merger that we've seen on TV?
I'm not sure how they interacted exactly with that. I mean, corporate communications has a variety of projects that they work on. We have routine staff meetings, but I don't know exactly what their role was, if any, in that process.
Okay. Are they some of the internal stakeholders you work with?
Yes, there's some, basically our internal stakeholder process for the grid mod has been specific to mostly the technology aspect, but they are also a group that we would work with. We haven't as much as many of the other technical departments within our company.
Okay. And I noticed on page 5, line 5, you say that you help identify public policy priorities and help shape the public policy and regulatory agenda. Does that mean that you may have assisted or consulted with Mr. Fenton on the timing of this filing?
Well, I certainly would not be in a decision-making capacity, but we often discuss essentially different dockets that are going on in terms of timing. I mean, obviously and I can't speak for Mr. Fenton, but he has an incredibly challenging job of making sure that the trains run on time with regard to regulatory. And so timing is a factor there. But I do know that at some point there was some discovery, I believe, that possibly Sierra Club, and I'm sorry, I'm forgetting what the party was, but they asked about who was the decision maker. And I can tell you that ultimately the head of our department is Ron Darnell. And so he was very much involved in determining the timing of this merger, I'm sorry, this abandonment case. Really bad Freudian slip there, but of this abandonment case, largely because of that timing of regulatory cases.
They are closely related, though the company's position is that they are distinct, right?
Well, certainly, and my testimony has been that they're distinct. And my main reason for saying that is that in all of my involvement and preparation for this, the merger, which I learned about on the day it was announced, was never a factor in any of the meetings I was involved in. So as we discussed all of the approvals that were necessary, and I was very much involved, as I'm sure you heard Mr. Falgren testify, on the Board of Finance approval that was required of our financial advisors and securities memorandum. That was a big part of the discussion in terms of timing. Never during those discussions did I hear anybody discuss a merger or anything having to do with any of that. So that is definitely my testimony. And to me, they're distinct. This was already underway long before we heard, at least I heard, or most people I interact with heard about any merger.
In those meetings, was Mr. Eldridge present in any of those meetings?
Mr. Eldred was not.
He wasn't?
No.
Does Mr. Darnell report to Mr. Eldred?
No, he doesn't.
Okay. Do you meet with Mr. Eldred or report to him on occasion?
Well, so I report directly to Ron Darnell, but of course, we're a company, so our entire executive committee, which is all the executives, are technically our bosses, as you would have in any company. But in terms of overseeing my work day to day, that would be Ron Darnell. I have in the past met with Mr. Eldred generally about company priorities and issues, but I mean, I haven't done so recently. It's probably been many months.
Okay. I was looking at your resume, and I noted during your time with Cuddy McCarthy, it says that you worked on I believe it says there that you worked on the ETA. Or is that separate down? Oh, it's under your legislative experience. I'm sorry.
Right. Mm-hmm. Yes, it was during the time I was with Cuddy.
Okay. Could you elaborate on that, what you did on the ETA?
Sure. I was what is described, I think even actually in state law, and when it comes to just lobbying and political involvement, the legislature is known as a subject matter expert. So in that role, I basically would assist the government affairs department, their staff, in terms of initially research and later just discussing potential language that would go into a bill. I would review bills for them. I would accompany them sometimes to meetings with legislators. And then sometimes I would be called upon to testify at a hearing, some of them being interim committee hearings, some of them being hearings during the legislative session.
Okay. So in your research, were you looking at other states' legislation, securitization legislation? Is that right?
That's correct. And I think I mentioned this at some point. I worked on what had initially been the predecessor, I guess, if you could call it that, of the ETA, which was then called the Energy Redevelopment Bond Act. And that had a lot of the securitization details in it. That was largely based on some of that research that I'd done on securitization from other states. Many other states have used securitization for many years. And so which is not unusual, when you draft legislation, as you probably know, you try to see what's out there and you try to find things that would make sense for New Mexico in terms of policy priorities.
Thank you. So I just wanted to ask you now about the other side of your title, the legal advisor. So are you registered as general counsel, or are you still as just an attorney with the law?
I am, right, no, I am, well, in terms of what the bar information and I believe what the Supreme Court registry and all of that has, they have my current title, Chief Policy and Legal Advisor. The reason that the legal is in there is that there are times when there's an intersection between policy, regulatory, and legal. And so there are times, just as I've done here, where my background in terms of just the work that I've done, it can come into play and is helpful in terms of rules and timing of, process and that sort of thing. So the procedural aspect of it can be useful, and that's why the legal part of it is in there. But I'm not part of the legal department at PNM. I work with them, and they're certainly, they're the ones that do the general counsel type work, the internal corporate work. I work with the policy department. So that's that aspect of it. But yes, I'm still registered, licensed in New Mexico. I'm also licensed in Arizona. Although right now I believe I'm inactive status in Arizona because I don't do any work there actively.
And this may just reflect my ignorance on this, but are your conversations covered with PNM executives covered by attorney-client privilege in any way?
That's a good question. I don't typically have conversations that require privilege of that sort. Sometimes there are conversations that I may be a part of where there's other attorneys there. And those, of course, would be covered by attorney-client privilege. Now, there were conversations, and on this I can be clear, when I was outside counsel and working on some legislative work where that would be covered by attorney-client. But in my current role, I don't believe that it would be covered in the same way. But I subject to check, I guess I should say, because I actually have not done that research.
I'd like to follow up on where on some of Mr. Tisdale's questioning from yesterday concerning the Section 16 funding. You're aware that PNM sought in well, first off, I appreciate the answer you gave concerning the reasoning, as far as you understood, perhaps, that that the funding hadn't been released, the 5 million, because PNM was waiting for a final non-appealable order. Is that right? That was my understanding from what you said.
Yes.
Okay. You're aware that in the 190018 case that PNM sought permission to make certain severance and training advance payments, right?
Yes.
Okay. And you're aware that the hearing examiner's recommended decision noted that even though there's no explicit authority in the Energy Transition Act to require such payments, that they approved it nonetheless, so that PNM could create a regulatory asset to preserve the company's ability to recover those costs and payments if it chose to make them, right?
It's been a little while since I've read the recommended decision on that case, to be honest with you, but I will take your word for it, Mr. Elliott.
If you want, it's on pages 99 to 100, and you can look at it later. So I suppose then, if the company chose to make those payments, the commission has given the company, the ability to create regulatory assets as a means of having some assurance that it will be able to recover those costs. So I suppose the company doesn't actually need to wait for a final non-appealable order in that case. Is that right?
It sounds like you're giving us advice on what we need to do. And maybe it was a compound question. So can you
Perhaps
repeat it for me?
the commission's recommended decision gives the company authority to make those advance payments, correct?
Yes, although it's been appealed. And so there's a little bit of there's a limbo in place. That's an issue.
Have you discussed this issue with anybody in the legal department?
The issue of the community funds in San Juan? No.
Yes. Okay.
No.
It doesn't fall, it would seem to me that it would fall under your duties as policy advisor, as they're described in your resume. Correct?
I think there's a lot that could fall under the policy advisor aspect of my title. I'll agree with that.
In terms of measuring impacts of programs that PNM is involved with, this seems to be one that you could measure the impacts of. Would you agree?
I think that the community funds are a huge necessity in the Four Corners region, yes. And I also think, though, that the releasing of funds is there's a big step there that we need to understand and make sure everybody's aware of, is that the state has a role in doing that. And just because funds have not been released doesn't mean that there hasn't been discussions occurring about the type of need in that area and the stakeholder process that's necessary for that to be developed through the state agencies. So I just want to make sure that you're clear about the fact that there is a whole layer of administration that's involved at the state level, and it isn't PNM sort of just transferring funds to Navajo or San Juan.
No, they're in effect, they're startup funds, correct? For the state agencies?
I think they could be seen as that, yes.
Okay. And are you aware that the Energy Transition Assistance Fund for Displaced Workers authorizes the acceptance of donations, gifts, grants, or bequests?
Yes, I believe that it does.
And to your knowledge, has PNM or PNMR or any of its executives made any contributions to the fund?
I'm not aware of any. I also, though, am not aware of what process has been set up for an actual fund, whether that's been set up at the Treasurer's Office, whether it's something that's been set up by the Workforce Solutions Department. I think both of those agencies would be important to that, but certainly you're raising some good issues to follow up on.
Okay, thank you. So now I'd like to draw on some of your background knowledge of the ETA. So on page 3, if you would turn to your rebuttal, please. You say that one of the points of the ETA is to, or I suppose, I won't summarize, I'll just look at it. You say that the ETA allows for, I'm sorry, one moment. In referring to the application, you say that the application achieves the end result of, or its principal purpose of entirely eliminating coal from PNM's generation portfolio, and in turn demonstrating measurable carbon emission reductions associated with PNM's generation fleet. Is it your understanding that the primary purpose of the ETA is only to eliminate coal from PNM's generation fleet?
It's my understanding that the goal was to eliminate coal and increase renewable energy development in general in New Mexico. And so from New Mexico utilities, obviously we're talking about a act that was passed by the legislature here and that provided a tool to the PRC in the form of securitization that hadn't been part of its toolbox, let's say. And so the PRC only has the ability to regulate utilities in the state. And so I think that was the goal, was to transition the state from its dependence on coal.
But you'll accept that it doesn't actually, or it's not actually doing that with this application, right? That the plant will still operate, correct?
Okay, I think you just asked me two different questions.
I will, let me rephrase it.
Okay.
The Four Corners power plant will continue to operate after the date of abandonment, correct?
Yes, after the date of abandonment in this application, that's correct.
And the San Juan generating station continues to operate and will continue to operate after the date of its abandonment, right?
I am not aware of that.
You're not aware of Enchant Energy's plans to continue to operate the San Juan generating station after the date of abandonment?
I am aware that there have been proposals made by Enchant Energy, and I'm also aware that there have been a lot of criticism and they've faced a lot of challenges in being able to capitalize those plans. So I am not aware that it will continue operating after PNM abandons it. And I mean, if I'm not aware of any evidence in this case to suggest otherwise. So no, I'm not aware that it's going to continue to operate.
But regardless, it's your testimony that closure isn't actually necessary as a part of the ETA. Right?
Well, certainly in this case, I don't know. That's right. I rebut your witness's testimony that closure is a requirement.
But it is your testimony that one of the primary purposes of the ETA is to demonstrate measurable carbon reductions, right?
That's correct. Yes. But just to add to that, again, on page 3, line 6, within associated with PNM's generation fleet.
Well, so this gets to a question that I wanted to ask your opinion. You're aware that the Energy Transition Act, or the legislation, amended the Renewable Energy Act, right?
The bill itself did, yes.
Right. And I'm specifically thinking of looking at section 62.16.4 of the renewable portfolio standards.
Mhm. I'm sorry, yes.
Okay. And paragraph A sets forth the standards that are to be achieved by utilities. And paragraph B states that in administering the standards required by paragraphs 5 and 6 of subsection A, and I'm now skipping ahead to numeral 4, that the commission shall prevent carbon dioxide emitting electricity generating resources from being reassigned, redesignated, or sold as a means of complying with the standard. And I'll note that the reference paragraph 6 there, the last sentence says, or number 6 says that no later than January 1, 2045, zero carbon resources shall supply 100% of all retail sales in New Mexico, and that reasonable and consistent progress shall be made over time toward this requirement. So my question is, what would how do you understand that provision as applied to this application? Or why should this provision not apply?
If you would give me just a moment, I'm actually pulling, because the version that I have doesn't have the red lines in context. I don't know if you're aware of that provision or of that capability on the legislative website.
I was using OneSource. That sounds like a fantastic resource to use as well.
Yes, OneSource is very good, but OneSource shows you what the chaptered legislation looks like. And the bill, which is what I have in front of me, shows you what the language looked like in its final form. And then what I'm looking up, and I'll explain why I'm doing that. What I'm looking up gives you what the amendments looked like coming out of the legislature. It's very much insider baseball, and I'm sorry for taking up your time, Mr. Hearing Examiner, with this exercise, but I just want to confirm something very quickly.
And Ms. Sanchez,
Yes.
while you're at it, so that we're all on the same page, so to speak, would you please give us that link?
Sure. Am I able to, let's see, give it to you in the sense of verbally, or do you want me to? Okay. Yes, it's, if you go to the New Mexico legislative website, which is www.nmlegis.gov, you can find legislation that way. You would have to click on legislation and then find the bill, which was SB 489.
Which is SB
489.
I'm not suggesting that we all do that now. I'm just suggesting that for the record that, yes, ma'am. Thank you.
Yes, thank you. I'm sorry. I should have done that to the end. Okay, now tell me again, Mr. Elliott, what section were you specifically looking at in section 29?
The amendment to 62.16.4. So I believe you noted that it is section 29 of the legislation.
Right. And what section under 62.16.4 were you reading?
B4.
before. Okay, I'm with you now.
And I'm asking this with respect to A6, which says that reasonable and consistent progress shall be made over time toward this requirement. And I'll note the reason I'm asking this is that it would seem to me that any transfer of an asset that's going to continue to operate after the date of abandonment would appear to me to fall under B4, which I would think give the commission pause in approving this abandonment.
So, and again, I'm testifying as a regulatory expert, not as a legal expert here, but I am very familiar with this bill and, what some of the intent and the discussions were behind it. But what I will say is that I think that this would apply if the purpose for this sale was to comply with that renewable portfolio standard. If a company was looking to make sure that it met the standard, and in doing so, their means to meet that standard would be to sell or transfer the asset, then I think that this would absolutely bar that. In this case, there's testimony, and I believe right after me actually is Mr. Phillips.
And I believe
right after me will be Mr. Phillips. And his testimony talks about the ability to meet this portfolio standard with or without this sale. So that is not the primary means of what's happening here. This is an opportunity to further other parts of the ETA, which are just as important and subject of a lot of, obviously, work by a lot of parties to transition the state out of coal. And that's one of the primary purposes of the ETA, and that's what we're furthering with this application.
But you'd agree that transferring these assets certainly furthers PNM's progress towards meeting its RPS goals.
I think it has multiple benefits, as we've talked about in testimony. Lowered emissions is certainly an important outcome of that. And in general, I think the state's policy is to try to move to less emissions on a much faster timeline than I think anybody expected in the last 10 years. So yes, this will help transition New Mexico's utilities, largest investor-owned utility, out of coal faster.
It'll help transition the utility out of coal faster, but these are plants that are based in New Mexico. So if they continue to operate, would that further the state's objectives of reducing emissions?
So there were multiple, and I know I testify as to this, there were multiple goals of the ETA. It was a huge policy effort that was passed at that point that the governor got behind. But a very important impact that was part of this transition discussion, and I think is important for the PRC to also consider, is the impact to that community of the job loss and economic hit that they will take. And you can imagine during the process, there were many people on that side of the aisle, if you want to call it that, but it wasn't a party issue. It was a economic justice issue. So I think just as important as a reduction in emissions and a transition to more or less emitting sources is also making sure that we're not devastating a community of New Mexicans with New Mexico jobs and an important economy. So yes, it will continue to operate if our 13% abandonment is approved, but there are some pretty important policy objectives, as you talked about before, actually, with regard to the community that are also being met through this transition.
We did talk about it earlier, so I'm not going to go back to the state of those funds. But let me ask you about the seasonal operating agreement then. Do you know if the impetus for the seasonal operating agreement was PNM's concern that Four Corners might jeopardize the merger?
I have never heard that suggestion until just now. So no, I don't think that was a consideration.
You have read the merger agreement, right?
I have read parts of it in preparation for this hearing, actually.
Are you aware the merger agreement requires PNM to have filed for some sort of exit from Four Corners prior to
Yes.
being completed? Okay. And sticking with page 3 of your rebuttal, it's your testimony that there's really the commission's hands are tied. The application's been filed that abandonment must be approved. Is that right?
I think the commission has a standard that they must look at for abandonment. And I think both myself and Mr. Fenton discussed that legal standard. And the standard is to ensure that there's a public benefit. So I don't think that they're supposed to not look at that. I mean, I think they're supposed to look at the standard for abandonment. The ETA specifically references section 62-9-5 for that standard. So, but as part of that, it's also one application. And so under the ETA, there is the Supreme Court has already said that there is a non-discretionary duty to apply the ETA to an application like this. And the ETA further says that if there is a denial of the financing application, that there will be an opportunity to go back and cure whatever the deficiency is and be able to reconsider that. So it's complicated.
Yeah, yes, I agree. Turning to page 18 of your rebuttal, you discuss here some of the harms that might occur if the abandonment's denied. Would you agree that one of the harms is would be to the potential merger?
That's not one of the harms that should be considered in this case. The two are distinct. And I expect, just given all the back and forth on documents in this merger, or in this, why do I keep saying that? In this abandonment about the merger, that issue was discussed in the merger case. But that's not a factor in this case.
Mr. Hearing Examiner, I think I'm done. So thank you for your time, Ms. Sanchez, and your answers. Appreciate it.
Thank you, Mr. Elliott.
Thank you, Mr. Elliott. Up next, we have Sierra Club, I believe. 30 minutes, Mr. Marks.
Thank you, Mr. Medeiros. Good morning, Ms. Sanchez. To put you slightly at ease, I'll just say at the outset, I'm not planning to ask you or debate any of the legal principles about any of the case law outside of your authority that were the subject of Sierra Club's motion, and hopefully we can stick to. I will ask you, though, a few questions about the ETA. But before I do that, I just noticed based on Mr. Elliott's testimony, cross-examination. You're employed by PNMR, but your boss, Ron Darnell, is employed by PNM, the subsidiary of PNMR. Is that correct?
I'm having a little bit of trouble with the audio, and I don't know if it's on my end, Mr. Marks, but I think what you asked me is whether, and you know what, just restate your question, because honestly, it was a little bit choppy on my end.
Is anyone else having trouble hearing me?
Yes.
Uh,
Yeah, when you moved the microphone closer, it seemed to help a little, Mr. Moses.
Okay. Well, please
That's
let me
better.
know. I've got the headset with a really great mic, and I can put that on if I need to. But let's try to go through. Ms. Sanchez, is it correct that you work for PNMR, but your boss, Mr. Ron Darnell, works for PNM?
I don't believe so. I think he works for PNMR.
Okay. So if I told you in his file testimony in case 20-00222, he said he worked for PNM, that would be a surprise to you.
I mean, I didn't review the testimony or anything in the merger case, so I can't really comment on that. I'd have to check with him to see who he works for exactly, I guess.
Okay. Turning to matters I think you should be able to answer easily. Are you aware of any provision in the ETA that changed the legal standard for abandonment?
No.
So the legal standards for abandonment predate the ETA and have not been altered by the ETA, correct?
That's correct.
Okay. If PNM's current abandonment was denied, nothing in the ETA prohibits PNM from filing another abandonment application in the future, correct?
This goes back a little bit to what we were discussing with Mr. Elliott. It's a single application. So, I mean, are you presuming in your question that it would be denied and the financing order would also be denied, or that one would be approved and one would be denied?
So first of all, to clarify my question, I'm asking legally. There may be factual reasons why PNM might say we can't, there's no other way to abandon Four Corners, but legally, so legally only, if the commission denies PNM's application for abandonment, first of all, you would agree at that point the financing order is moot, correct?
I would expect that there'd be a finding on the financing order.
Doesn't the
In this
financing?
application. Sorry.
I'm sorry, I didn't get what you said, ma'am.
In this application is what I added, but I apologize for the crosstalk.
Thank you.
Okay, so you think there could be a financing order in the absence of an approved abandonment?
No, I don't. And so my question, or my, I guess, answer to you is that if there's an abandonment, if there's a denial of the abandonment, then I would expect a denial of the financing order or some action in this case on the financing order.
Okay. All right, well, let's just stick to the abandonment. If PNM's application for abandonment is denied, do you know of anything in the Public Utility Act that prohibits PNM from refiling an abandonment for Four Corners in the future with the same or different factual circumstances in terms of?
Wait, hold on. Ms. Sanchez,
Yes.
if 6295, if company is found to not meet the standard, why would one go to the trouble of going through the whole exercise on a financing order if the company hadn't met, hypothetically, the standard for abandonment?
Because the Supreme Court has said that the PRC has a non-discretionary duty to apply the ETA.
Okay, here's applying the ETA. The company has not met the standard for abandonment, therefore a financing order is not required. Is that a finding?
I don't think that's an action under the ETA. It essentially says that if there's an application and the PRC has reviewed it and it meets the standard, then it should be approved. If it doesn't meet the standard, there's an opportunity for the company to correct or cure, whatever term you want to use, to revise the application and resubmit it. So this is sort of where it gets a little bit,
Right.
what I
But
call
then,
complicated.
but that still doesn't get to the entitlement. There would be still no entitlement in that particular docket to a financing order, right?
The two are linked in this case. So I think practically speaking, if there was a denial on the abandonment piece of it, I would still think there would be an expectation for some outcome on the financing application piece.
Because you might hope that somewhere along the line, somebody might change their mind on the abandonment findings and therefore you can move forward on the financing order.
I don't know about changing their mind, but there's
Well,
the
a change in, you know what I'm saying?
Yes.
I think without, I'm trying to be delicate about this.
I understand. I guess I was wondering when you said
I
change your mind.
understand. I understand all too painfully, frankly, how this works. And I'm none too happy about it ever. I will just state for the record. So, and I'm not going to go any further than that, but I think you but you can, if the abandonment is, and I'm not, obviously not making any finding about it or suggesting anything. We're just speaking hypothetically about how these statutes work, right? So the expectation would be that, assuming there's a finding that it doesn't meet the standards for abandonment, the application, you would still expect, what would you expect?
I think that based on what the Supreme Court has said, that there's a non-discretionary duty to apply the ETA. I would
That's
expect
applying it.
I would expect that the ETA would be applied with regard to the financing order.
So the commission would be saying, you don't meet the standard for abandonment, but here's a financing order anyway.
Not necessarily.
That would be a non-bypassable charge for 25 years, which essentially would be the equivalent of a student loan attached to every utility property in the state, that being a ratepayer property that is a customer of PNM. Whoever the customer might be for those 25 years attached to that property, there's a requirement of a financing order in that case when the standard has not been met for abandonment.
No, sir, that's not what I'm saying. I'm just saying that the two are linked.
Okay. What do you mean by linked?
I mean that it's a single application. So if there is a denial of the abandonment, the application has been denied, but under the ETA, there's an opportunity to bring it back and address what the deficiencies were.
Within what time period?
I don't believe it has a time period set out, but I'd have to double check.
Well, it does have a time period, but you wouldn't be able to cure it within the same docket, within the same statutory time period for the clock running, which is now around December 10th. So let's say let's say there were a denial based on not meeting the standard for abandonment. And again, it's just completely hypothetical. Let's just say for the sake of argument that there's a ruling on November 15th of a final order of the commission denying the abandonment for not failing to meet the standard for abandonment. Are you saying that you would have the ability to cure within those 3 weeks?
Excuse me, Mr. Hearing Examiner, I'd have to go back and look, to be honest with you. And I'm not trying to avoid your question. I need to.
Well, it's obviously a significant question if you can't say no.
It's a
That no,
question in my mind, yes.
the clock, so a denial of abandonment, the clock would not start over from the filing of an amended application?
No, I think it would. I think it potentially would. I just would need to confirm that is what I'm saying. I'm not suggesting that you would have the exact same timeline necessarily. But I would need to look, because I hadn't thought about that question before this.
Yeah, because a lot could happen between a November 15th final order and a request for consideration between the statutory deadline. Not to put too fine a point on it.
Yes.
The idea, because, and the parties should mark this for potential briefing. I don't know whether we're going to need briefing on it, but I'm just marking this as one issue that you might want to potentially brief. So I'm sorry, Mr. Marks, I took up some of your time. I'll add it back to your time. Go ahead.
Hey, thank you, Mr. Medeiros, and thank you for concluding by reminding us that this is something that should be addressed in briefing. It's not, and the fact that Sierra Club is not going to debate these points shouldn't be taken to mean that we concede to either PNM's position on this. Ms. Sanchez, assuming that the outcome of this proceeding is that the abandonment application is denied, is there anything that legally prevents PNM from refiling for abandonment in the future for Four Corners?
Legally, no. Practically, yes.
Okay. And is it PNM's position that if abandonment is granted, the ETA prevents the commission from disallowing any of the Four Corners costs?
I'm sorry, Mr. Marks, you broke up. Could you restart the question?
Yes. And I don't mean to be in your face here, but I think I need to be very close to my computer. Is it PNM's position that if abandonment is granted, the ETA prevents the commission from disallowing any of the Four Corners capital costs that were at issue in the 2016 rate case?
When you say any of the capital costs, I assume you're talking about the those that were subject to the debt-only return. So you're referring to those that have been, I guess, talked about in this case as related to prudence?
Yes.
Okay. I think that I may have testified to this yesterday, but I will say that I don't believe that the ETA has any requires a prudence review. It simply states that costs that were in base rates as of January 1st, 2019 are considered abandonment costs. Anything beyond that, though, there is a requirement within the ETA that it be reasonable. So there's sort of a timeline issue, right? Things that were in base rates as of January 1, which includes the debt-only return, which would carry forward into anything that gets securitized, and Mr. Baker can talk about that further. But from January 1 forward, those costs can be reviewed for reasonableness.
So you're talking about costs incurred subsequent to the 2016 rate case. For the costs that were at issue in the 2016 rate case, what you called the debt-only costs, do you agree that it's the company's position that the commission is prevented from disallowing any of that to go into a financing order?
It's the company's position, I believe, that that the costs that were in base rates as of January 1, 2019 are appropriate abandonment costs. There was not a finding of imprudence. Those were allowed to be included in base rates, and thereby they're prudent. And so they should be allowed to be abandonment costs. We have, though, as you know, Mr. Marks, have provided additional testimony on prudence, and Mr. Graves gets into a discussion about determining prudence issues.
If the application for abandonment is denied, is there any provision in the ETA that prohibits the commission from conducting a prudence review of Four Corners in a subsequent case?
Not to my knowledge.
Okay. In that hypothetical, where this abandonment is denied, would you agree that such a prudence review is likely to occur in PNM's next filed rate case?
I don't have any way of knowing that, Mr. Marks. I don't know.
Okay. Do you know that whether or not the final order in case 16-00276 deferred a prudence review to PNM's next rate case?
I'm aware of that, yes.
Okay, so you don't think it's likely that if there's another rate case and the issue is not resolved in the present case, that prudence would be considered in that case, the rate case?
I believe that that's what's in the order, and we all want to follow orders. So it's likely, yes.
Okay. And I think you just said this, but in your rebuttal testimony, you discussed that you believe the Four Corners capital costs that were at issue in 2016 are currently in PNM's rates and therefore eligible for inclusion in a financing order, correct?
Yes.
Okay. There was PNM testimony earlier in the hearing that the company had planned a 2020 rate case filing, but changed that plan due to the COVID pandemic, correct?
That's correct.
Okay. Would you agree that if the company had filed a rate case in 2020, it is possible that the prudence review that the commission deferred in case 16-00276 could have been adjudicated in that 2020 rate case?
Yes.
Would you agree that such an adjudication could have resulted in some or all of the Four Corners capital additions being removed from PNM's authorized rates?
That could have been as much of an outcome as it being seen as prudent.
Right. Were you part of the discussions about timing for filing the rate case?
Generally, yes, I was involved in the early discussions and also in the discussions related to the postponement of that rate case due to the pandemic. In fact, I think I was on some calls where stakeholders were involved, including yourself, Mr. Marks.
When was the decision made not to file a rate case in 2020?
I'm trying to remember what the date was when we had some stakeholder calls related to this. It would have been shortly before that. And I think the stakeholder calls that we had were sometime in May. I'm having a hard time remembering right now, but I think it was probably maybe early May, maybe late April. It was sometime in the second quarter probably of last year.
That's close enough. And if I could remember, I would help you, but your memory is better than mine on that. Is it correct that neither you nor Mr. Darnell knew at the time that a merger was being negotiated with Avangrid?
I did not know about any merger negotiations. I can't speak for Mr. Darnell, but I believe that he testified in the merger case that he was not aware of it.
Okay. When did you first learn that there was or would be an agreement for PNM to transfer its Four Corners interest to NTEC?
I believe it was on or about November 1st.
Are you aware of any discussions within PNM about the benefits of avoiding a potential disallowance of Four Corners cost by sequencing the abandonment filing ahead of a new rate case?
I am not aware of any such discussions.
Okay. Changing subject slightly, in your opinion and based on your personal knowledge, what is the legal test the PRC uses for imprudence?
You're now definitely switching gears a little bit, Mr. Marks. And I'm so sorry. Is there a place in my testimony that you can point me to?
You know, I would say you cover in your rebuttal testimony, you speak about remedies for imprudence. I'm not asking you about remedies. I'm asking you about the test for imprudence. And if you don't know, then you don't know.
So and I'm sorry, I'm sort of shifting gears a little bit too much at this point, but I know that the property needs to be used and useful. I don't know why I'm having a blank right now in terms of being able to exactly spell out the legal standard. And I'm sorry about that. I've got too much ETA on the brain.
Okay. Mr. Medeiros, I think I'll end at that point. And
Thank you, Mr. Marks. I'm sorry for interrupting your cross-examination, though. It's just an issue came up that I thought I needed to understand immediately. And every once in a while, I'll do that to you, so I'm sorry.
Mr. Medeiros, I appreciate you using your time on that issue, which was interesting. So no apologies necessary. I think you used about, well, you're the timekeeper, but whatever time we didn't use, we would like to add to Mr. Graves.
Well, we're not allowing for that. We didn't allow for that. To the extent I did before, I'm going to stop that practice. The time that you allotted beforehand that you committed to the witness, is that what you were given? And I do recall in either 1918 or 16270, probably 16276, we had this issue come up where you wanted to use unused time for the next witness, and I'm not going to engage in that practice going forward. So,
Mr. Medeiros,
I'm going back to our old, Mr. Marks. I'm going back to the old time not used is not time carried forward. And I can go back and find where we indicated that in many cases about me being myself and Chief Hearing Examiner Schanauer. To the extent that he has allowed that subsequently, I'm going back to the practice that we had.
Mr. Medeiros, just to clarify then, so if a priori I had said we only want 20 minutes for Ms. Sanchez, I could reserve 10 minutes?
You ahead of time, you could say, I'm only going to use X amount of time here, and I'm going to move that time forward. But I'm not going to go into a cross-examination and then end it early and say, okay, I want to use the rest of that time with another witness. In other words, time estimated maybe time reallocated. Time saved, time not used is not time saved for a next witness. There's a distinction there.
I understand, Mr. Madera. It's not worth consuming hearing time on this. I did indicate last night that we only expected to use 15 or 20 minutes, but I don't need the 10 minutes.
Oh, well,
right?
that was my fault. I thought you were going to use the whole 30. We didn't have that discussion that I should have had with you. I assumed you were going to use the whole 30.
I did indicate 15 or 20, and I think
I'm sorry.
I think
So
I
I'll
used
give
less
you-
than 20, but if you,
Yes. No, that's a misunderstanding on my part because
Right.
I was rushing ahead and I didn't do the discussion with you that I should have had. You took 20 minutes with Ms. Sanchez. Therefore, consistent with past practice, you have another 10 minutes to use with another witness. I'm sorry.
and we'd like that for Mr. Graves, but we will try not to use it because we will try to be efficient.
You getting your time?
And so I will not, I'm trying to rush through this and I didn't have that conversation that I've had because I know some people find it annoying. It's this horse trading thing about time. And so I was rushing ahead, but I should be consistent with the practice. And if I had been, then we wouldn't have had that discussion. So it's all on me. I apologize. So that is done. Ahead of time, I do recall that Ms. Beagles asked for 5 minutes with Ms. Sanchez pursuant to an email last night. So Ms. Beatles, is that still accurate?
Yes, it is. Thank you.
Thank you. Please proceed.
Good morning, Ms. Sanchez.
Sorry, I was on mute. Good morning.
I have a couple of lines of questioning. One is about the timing of the bond issuance relative to the time that the plant shuts down. So it's an open-ended question. I would like to know what the considerations are about when those bonds are issued. Is it shortly before, shortly afterwards? Are there any constraints on that timing?
So I think the timeline at this point is that the bonds would be issued soon after the abandonment of the plant of PNM's share. So if the abandonment occurs, let's say on 12/31/24, then the bonds would be issued ideally the next day, but it's a holiday, so it would probably be that next week. And the consideration is you want to have the timing of those two events, the sale, the transfer of the asset, and the issuance of the proceeds be close together in time. In terms of other considerations, market considerations, timing of the bonds and interest rate and all of that, probably a better question for Mr. Atkins.
Okay. Why does it need to be relatively close to the abandonment? Is that for marketability or is it for the utility's financial interest?
It typically is a function of the bonds themselves. It's a marketability structuring issue. It's not to do with the utility, particularly because the asset is essentially being converted into a security. That's what securitization is you're transferring an asset into securities. But the actual bonds will be issued by a subsidiary, and the charge gets collected by PNM and transferred to that subsidiary. So it's really just a timing in terms of the asset transfer.
Do you know, and you may want to refer this question to Mr. Atkins, do you know whether there are any constraints on the timing of the issuance, like they can be issued no earlier or later than 90 days after the event that is being financed?
I don't know specifically if there are some rules related to that, but given that there's securities, obviously there's probably a lot of rules that constrain that sort of thing, and Mr. Atkins would be the right source for that.
And one more question. In response to the AG's questions about why PNM has not yet released its pre-funding of just transition assistance, your response included, at least in part, a reference to the state's role in the administration and distribution of these funds. Is that right?
Yes.
What about the pre-funding of the coal mine workers severance in training? That did not go through the state. Is that right?
That's right.
That was to go to an escrow agent.
That's right.
And is PNM also withholding the funds until the appeal is resolved for that purpose?
I don't actually know what the status is of that funding.
Okay, that's all. Thank you.
Thank you, Ms. Beatles. Up next, we have the Water Utility Authority, who has reserved 15 minutes with Ms. Sanchez. Mr. Harris, do you still have that amount of cross-examination time for Ms. Sanchez?
No, sir. I'll only take 10 minutes of it, and I'd like to take the extra 5 and assign it to Mr. Phillips.
So you have 10 with Ms. Sanchez, 20 now with Mr. Phillips. And I want to go back to Mr. Marks for a second to indicate that what I've done on my tally is added those 10 minutes to Mr. Graves. So right now I have 70 minutes with Mr. Graves, tentatively. All right, 10 minutes with Ms. Sanchez. Please proceed, Mr. Harris.
Thank you, Mr. Hearing Examiner. Good morning, Ms. Sanchez.
Hi, Mr. Harris. How are you?
I'm doing fine, thanks. The questions I have are related to your familiarity with the ETA. It's my understanding that part of your familiarity comes from your work on the bill during the passage of the bill back in 2019. Is that correct?
That's correct.
Okay, and at that time, you were advising the State Governmental Affairs Office about the bill?
No, I was advising PNM. I was working with the Government Affairs, Public Affairs Department at PNM.
Okay, thank you. I misunderstood. Did you do any drafting on this bill? Or
I considered language. I looked at language. I proposed language, but the actual drafting happens with the Legislative Counsel's office.
okay.
And so, I mean, I certainly looked and considered various parts of language. I guess it's a big bill.
Okay, yeah, but it was over 80 pages, correct?
At one point, yes.
Okay.
Actually, the final product may be that long too. I don't remember, but yes, very long.
Anyway, it's a long bill. And did the Governmental Affairs Bill produce the first draft of the bill?
Are you referring to our internal department? Like here at PNM?
No. Who, to your knowledge, produced the first draft of the bill?
That would be the Legislative Counsel's office at the legislature.
Okay, and did they draft it?
They did.
Okay, I have no further questions. Thank you.
Thank you, Mr. Harris. Next up, we have staff, Mr. Borman. I have you down for 40 minutes, 40 minutes. Do you still have that amount of cross-examination, Ms. Sanchez?
Thank you, Mr. Hearing Examiner. I do not have that much cross-examination for Ms. Sanchez, thanks in part to examination that you performed earlier and that Mr. Elliott performed earlier. That has shaved a decent amount of time off of mine. So thank you for that.
You're welcome.
May I proceed?
Yes, unless you wanted to reserve time for another witness.
No, thank you.
All right, thank you.
Good morning, Ms. Sanchez.
Good morning, Mr. Borman.
Now, you had a discussion yesterday with Ms. Nazi, kind of about your work at Cuddy and McCarthy on behalf of PNM, and particularly before the legislature and working on the Energy Transition Act. Do you recall that?
Yes.
And I think you described it as working with a number of other advocates on the bill. Is that correct?
Yes.
Was anyone from the PRC one of those advocates?
Well, I don't tend to refer to the PRC as advocates. But yes, there were a number of people that were involved in discussions. And so the staff at PRC was in some of those meetings, as were certain commissioners had come to some meetings as well, although they mostly just observed.
So who was involved from the PRC?
I remember Ms. Beatles when she was at the staff at the PRC coming to some of those meetings. I also, there was somebody else who is escaping me that was part of the utility staff that had come. So there were a variety of folks that would join those meetings from time to time.
That work is part of why you are familiar with the Energy Transition Act. Is that correct?
Yes, I would say that probably, yes.
Okay. Now, is there a statutory purpose set forth in the Energy Transition Act?
Unfortunately, there's not. And just for information, there used to be a process for providing a purpose section in legislation. And in recent years, the Legislative Counsel's Office has stricken any purpose sections. So I think at some point in an early draft, there may have been a purpose section drafted, but it was never incorporated.
Okay. But if you have your rebuttal testimony, you could pull that up.
Sure.
And on page 2 of that.
Yes.
Okay. You actually give us a purpose of the ETA, don't you?
Yes.
Okay. And I think what you say is the ETA is designed to accelerate the removal of coal-fired generation from a generation portfolio through securitization. Is that correct?
I'm
Yes,
sorry,
that's what I-
removal of coal-fired generation.
From a generation portfolio through securitization.
Thank you.
Please proceed. That's correct?
Yes.
Okay. Now, I read this as to say that the ETA is to accelerate the removal of coal generation from a utilities generation portfolio. That's really what we're saying here, right?
Yes.
Okay. Would you say it is also designed to accelerate the elimination of coal-fired generation from the state of New Mexico?
I think that it is a policy to try to change the way that we obtain our electricity. So one of the goals was to transition to renewable energy. Yeah.
Well, wait a minute. Now I'm not following. Is that a yes or a no? I mean, it sounds like it was both. Is it also designed to accelerate the elimination of coal-fired generation from the state of New Mexico?
Coal-fired generation from the state of New Mexico. I think that was a consideration. Yes.
Well, is that what it's designed to do?
I think there are several designs, let's say, several aspects of the law. It has multiple purposes.
Okay, so that was at least one of the goals, was to accelerate the elimination of coal-fired generation from New Mexico?
To the extent that the PRC has the ability to do so, yes.
Now, it's your understanding that the Four Corners plant is scheduled to close in 2031. Is that correct?
From all reports, yes.
Okay. And that's the current plan, regardless of whether or not the abandonment that PNM seeks in this case is granted. Is that correct?
That's my understanding, yes.
Okay. So that being the case, the application of the Energy Transition Act to this case is not accelerating the removal of coal generation, at least in regards to the Four Corners plant, is it?
As I stated, it removes the coal-fired generation from PNM's portfolio.
I'm
That's
sorry,
not what I
man, you
asked you.
broke up. I'm sorry, man, you broke up. As I stated,
It removes coal-fired generation from PNM's portfolio.
But that's not what I asked you, is it? I asked you, is the application of the ETA, in this case, going to accelerate the removal of coal generation from the state of New Mexico?
No,
Okay. Are you aware of any party, either here or in Arizona, who is interested in extending the life of the Four Corners plant beyond 2031?
I am not specifically aware of any parties, no.
You're not specifically aware, are you generally aware?
Well, I mean, I would expect that there are probably interests in the Four Corners area that would prefer to have a good paying job longer than beyond 2031.
Are there
So-
perhaps,
Ms. Foreman, stop, please. We've got that time lag back. Has something changed in the room with you, Ms. Sanchez?
Nothing has changed, sir. But I did start to hear it myself when Mr. Borman came on.
Thank
I
you,
am
ma'am.
alone. I can tell you that I'm in my office right now.
Silence is just to see whether it's still there. So somebody else, and I didn't mean to accuse you, Ms. Sanchez, it's just the last couple of times it was fixed when Mr. Gifford and Mr. German fixed the problem, but the problem has come back again.
I understand.
Let's see, I'm sorry.
Mr. Hearing Examiner?
It's not coming from you, I can tell now. I'm sort of trying to look, understand how this happens, because it did, when we moved from you talking to me talking, it didn't happen, but then once that stopped, it started again, and it's back. So where is it coming from? Okay, Mr. Foreman, go ahead. We'll see. We'll try and sort through it.
I'll try to remember exactly where I was. I think I was asking if you were aware of, is there anybody perhaps associated with the Arizona Corporation Commission that might be suggesting extending the life of the Four Corners plant?
I don't know.
You're not aware of anything?
I don't know.
Okay. Now, on page 11 of your rebuttal testimony, and I'll give you a second, I'd like to turn to that. You have it?
Yes, I'm sorry. I'm there.
Okay. You begin a discussion of the $16.5 million in community assistance dollars that PNM is seeking to recover in this case. Do you see that?
Yes.
And I think you talk about how the statute does not indicate when a facility closes in regards to compensating the affected community. Is that correct? Yeah.
Yes.
So assuming the commission approves the requested abandonment and the $16.5 million in community assistance funds, what happens to that money between the time of the abandonment and the actual closing of the facility?
Well, I presume that the state agencies that are involved would develop a process for determining how best to allocate those funds.
And what are those funds designed to do?
Well, there's 3 different funds. I think generally they're all intended to assist that community with the impact of a change in the economics of the region. And basically it's the Workforce Solutions Department, which is supposed to deal with displaced workers issues and retraining. There's the Economic Development Department, which has a fund to deal with economic development, transition, presumably other type of industry, other jobs and development of such. And then the third one is the Indian Affairs Department, and that is supposed to deal with impacts to the Native communities in that region.
The impacts from the closing of the facility.
The impacts from the change in general that's going to come from, yes, a transition out of coal.
Okay. But these these workers won't be displaced till, at least according to the plan, 2031. Is that correct?
I'm not sure what the timing would look like. I don't know if everybody gets sort of, laid off at that point, or if there's a plan for it being done in rounds. I don't know, but yes, there's an expected closure in 2031. So there will be.
Foreman? I'm sorry, Ms. Sanchez, I thought you were done with your, please proceed. I'm sorry. No, please proceed.
I wasn't sure where I was, but I said I presume that they would be losing their jobs at that point in 2031.
Yeah, your answer so far was, I'm not sure what the timing would look like. I don't know if everybody gets sort of, laid off at that point, or if there is a plan for it being done in rounds. I don't know. But yes, there is an expected closure in 2031. So there will be
job loss.
Right. Job loss. Okay. Thank goodness for Mr. Lee's excellent real time that I can interrupt someone and still retrieve it. So we really do have an issue. So I have a suggested solution. I'm going to start going through the tiles and removing inactive folks until I isolate who's causing the feedback or time lag. So before I start doing that, would everybody please look at their connections to see where it might be coming from? Because I'll just start with a particular tile and I'll start removing folks who are inactive. Because it's not coming from PNM this time. It's not coming from staff apparently this time. So there's somebody inactive who's causing this time lag. God, everybody, yeah. Is it just me, or am I still hearing it?
Mr. Medeiros, I hate to cast aspersions, but I see Mr. Borman's square lights up occasionally, and I think it could be him.
Cross-examining.
But no, when Mr. Medeiros was speaking, you lit up a little, so.
And I had heard from Ms. Kippenbrock that was something to look for. There are too many. I appreciate you spotting them, Mr. Marks. So the thing was, it didn't seem to be always coming from Mr. Borman. It seemed to change during his cross-examination. That's why it might not be him. But the lighting up is a good indicator that that's the source of the issue.
Mr.
All right, well.
Might I suggest that a way of isolating rather than eliminating individuals in their tiles is that if everyone were able to mute themselves, and then you could be the only one speaking, and we could then try to isolate it that way, and we could find out if it is Mr. Borman or if it's coming from somewhere else.
Okay, everybody please mute themselves except for me, including PNM and PNM's witness, Ms. Sanchez. Thank you. All right, I do not hear it now. Do you all hear it now? Yes or no? Okay. Mr. Borman, unmute yourself. And Mr. Gifford and Ms. Sanchez. Okay, I do not hear it right now. Do you? I just heard it, yes. Yeah. So,
I think the way to fix it is the feedback's coming from the simultaneous, the microphone is picking up the voice going through the speaker and the speaker's own voices. So if people that have their microphones unmuted would just put headphones on so that their own microphone would not also pick up the audio coming from their computer and the speaker, that would stop this, I believe.
okay, thank you, Ms.
I can try using my headphones for this, and perhaps that could help alleviate the problem.
Thank you, Mr. Borman.
Can you hear me?
Yes, sir.
Okay.
I didn't hear any, and I'm speaking now only because I want to hear, we've got that time lag and I'm not hearing it through my earbuds right now. Is
Okay.
anybody picking up anything?
I
All
am
right,
not
let's
sure.
Thank you, Mr. Lee. Most importantly, you, of course. So thank you, Mr. Lee. Yes, Mr. Borman, please proceed.
Okay.
I'm sorry for that. I apologize for the technical difficulty. It's nobody's fault. It's frustrating. I'm sorry. Mr. Borman, please continue.
Okay. Ms. Sanchez, my math isn't the best, but it tells me that the year 2031 is 10 years in the future from now. Is that correct?
Yeah, I would agree with that. Yes.
Okay. Do you know if PNM was contemplating the abandonment of Four Corners 10 years ago?
In 2011, I don't know.
Okay. Do you know if PNM was contemplating the abandonment of San Juan 10 years ago?
I don't know.
What happens if between now and 2031, facts change such that the closing of Four Corners is further delayed? What happens to those dollars then?
Which dollars are you referring to, Mr. Borman?
The 16.5 million in community assistance funds.
Well, I assume that there would be some kind of process, as I mentioned before, from the state agencies on how to administer those funds. I'm not sure that I'm in a position to be able to answer that.
Okay, but it would be correct at least that ratepayers would have paid those dollars, right?
They are part of the securitization that's secured by the charge that goes to customers, yes.
So that's a yes.
Yes.
Okay, thank you. I don't have any further questions.
Thank you, Mr. Borman. Ms. Sanchez, I did not intend to get adversarial with you over that issue. I'm trying to understand the company's expectations. And I want to obviously apply the Energy Transition Act and any act that I'm trying to apply it correctly.
I understand,
Fairly.
Mr. Harris. It's okay. You have a very important job to do. I get that.
But thank you. I want to get your help and I'm not going to, I am going to ask you this question and then I want your help with setting the parameters of potential briefing of an issue, of a critical issue in the case. And at one point you said that there was not, words to the effect of there's not a finding that the undepreciated investment between 2016 and 2018, the SCRs and the other capital investments, right? That there's not a finding of imprudence. You're talking about those particular investments.
Yes.
Undepreciated. Okay. Therefore, you said they are prudent. That's interesting, because that's the key linkage. You see that therefore is really critical because I'm not sure the key linkage is there. Okay. And so I'll refer you to page 21 of your testimony.
Sorry, your rebuttal? Is that
your rebuttal? Yes, page 21 of your rebuttal. And you asked the question, is PNM's recovery of its undepreciated investment?
Sorry, Judge, you're breaking up. You were asked the question.
Is PNM's recovery of its undepreciated investment in FCPP subject to the ETA, which is now in effect? Question. Did you hear that, Mr. Lee?
Yes, sir.
Okay, sorry about that. Your answer is yes, and based on the plain language of the ETA, the undepreciated investments in FCPP being recovered in rates as of January 1, 2019, are not subject to further commission limitations. When we went down that rabbit hole a little bit with Mr. Marks, I believe, and he asked you about, well, what if the commission examined or did a prudence review in the subsequent rate case, right? That, and we don't know the answer to that. That really is not the point, but there's a permanence issue because there are certainly expectations that once these bonds are issued, and I know reading Mr. Atkins' testimony very carefully, that it is critical to the bondholder community, it's critical to PNM and shareholders that there be some certainty about what's being recovered pursuant to the energy transition charges, isn't there not?
Yes.
So once something has been put in rates and is being recovered, and then it transmutes into part of the energy transition charges to which the energy transition bonds are recovered pursuant to the special purpose entity, how would that be unwound in order for there to be a subsequent review of those undepreciated investments that we're talking about between 2016 and 2018? How could that be unwound? And I'm not going to ask you for an answer because I'm again, I want to see if this is sort of the start of a dialogue, and I'm starting it with you in order of what I call, I don't know if you're familiar with the term of troubling an issue, troubleshooting, but it's troubling an issue, really evaluating the issue and stretching it to its limits in order to see, to understand the full interplay of the Energy Transition Act and its control over the Commission's rate-making authority, stretching this issue to the legal limit and troubling it. So I guess, and again, you don't have to answer this, but parties, this is start a dialogue with you to refine the legal issue. And what I would do is refer you to our recommended decision on financing order in case number 19-00018 UT at page 94. The second full paragraph, we write, the ETA preserves PNM's ability to recover certain costs that the Commission has or appears to have previously determined to have been reasonable and prudently incurred. You see that shift from has or appears to have been previously determined? Now cross-reference that to Ms. Sanchez's therefore, where there's a linkage missing. And the question whether that linkage is material or not any longer, given what has happened. So going back to Ms. Sanchez's testimony that I was talking about, a rebuttal testimony, I might ask the question for legal briefing, what if the Commission had reserved the right or authority to, in effect, claw back or provide some form of refund subject to the subsequent prudence review in the next, now never held, rate case? Did the Commission suggest this or hold this out as an option in the final order, the revised final order in case number 16-00276 UT? And query whether in that regard, going back to the language that I quoted from our recommended decision on financing order on page 94, whether the Commission has or appears to have determined the capital the undepreciated capital investments in question have been, whether the commission has otherwise found them to be reasonable and prudently incurred. Because, again, going back to that linkage, while the FCPP investments for this period were allowed to be recovered and raised as of 2018, therefore meeting the January 1, 2019 qualification, the commission reserved judgment on that prudence of this investment, of those investments. So that's quite a mouthful I put out there, but I think we need to try and focus. And I think that one word that Ms. Sanchez said, therefore, gets to the heart of the matter, if you follow me. All right, I'll leave that there and let that marinate for a while, but we'll come back to it as the hearing continues. And so that that's at least my first take on attempting to treble that issue, if you will. Mr. Gifford, with that long-winded colloquy, I will hand it to you for redirect, if any.
No, thank you, Your Honor. A few questions, if I might, as I marinate myself as well, Your Honor. I want to take you back to yesterday, Ms. Sanchez, in your discussion of the decommissioning and reclamation provisions of the purchase and sale agreement with NTEC. Do you remember that discussion?
Yes, I do.
And what's your overall understanding of how the purchase and sale agreement handles the environmental liabilities, the decommissioning and reclamation issues at Four Corners?
So, and I know we got into the weeds a little bit. I too was squeamish, Mr. Hearing Examiner, in that whole discussion. I'm here as a regulatory and policy expert witness for PNM, and not as testifying as a lawyer for legal conclusions. So I did a little bit of parsing of a contract on the fly, but I will say that generally my understanding is that the issues of remediation and decommissioning are handled through contract, that being the PSA and the provisions under the PSA, where there is joint and several liability. I think that at some point, Mr. Tisdale asked about what happens if NTEC can't pay, who's on the hook, so to speak, but with joint and several liability, the parties that have been involved are still going to be responsible. And that would include NTEC, and they've had 7% ownership regardless of this transaction, as well as APS, PNM, TEP, SRP. And I'm sorry for all the acronyms, Mr. Lee. I can spell those out if you need me to. But I think that the owners basically that are have been a party to Four Corners would have joint and several liability.
And also going back to your discussion with Mr. Tisdale, he asked you several questions about CERCLA liability. Is Four Corners a CERCLA site or under investigation as a CERCLA or Superfund site?
Not to my knowledge, no.
And do you know whether PNM is, you were asked whether PNM has estimated the amount of its CERCLA liabilities. Do you know if there is such an estimate of CERCLA liabilities?
Not to my knowledge.
And is CERCLA liability an issue in this case?
No.
Now going to today, a couple quick questions as well, Ms. Sanchez. Mr. Elliott asked you about the release of the community transition funds. Do you remember those questions?
Yes.
If the appeal of the San Juan financing order were withdrawn, could the funds for the community be made available?
Yes.
Another question that you were asked by Mr. Elliott was whether or not Four Corners will remain operating after PNM's abandonment and sale. Do you remember that question?
Yes.
Will Four Corners be operating in the same manner after the sale, the abandonment and sale? as it is
If-
now?
No, if this abandonment is approved, then there's actually a seasonal operations agreement that would apply. And so there would be a reduction in greenhouse gas emissions estimates of 20 to 25%.
And two final questions to maybe take us out to our quick morning break. You were asked a series of questions by the hearing examiner and as well as Mr. Marks about how the ETA interrelates with the abandonment standard. Do you remember those questions?
Yes.
I would ask, could you go to Mr. Fenton's testimony?
Sure. Give me just a moment.
Is it his supplemental?
The direct testimony of Mr. Fenton and page 7.
I'm there.
And I'm not going to ask you to, I'm not going to take the time to ask you to read that into the record, but does Mr. Fenton provide an answer to that question of how the Energy Transition Act and the Public Utility Act interact with regard to the legal framework for this application?
Yes, he does. He discusses it at page 7 after the first question. He goes into a discussion about the interaction between the two.
Thank you, Ms. Sanchez. Give me one moment.
What in particular there, Ms. Sanchez answers that question? That troubling, I'm going to use a different word, that thorny issue regarding.
I'm sorry.
Yeah, it established, he says there on page 7 that line 13 that the ETA, the Energy Transition Act, establishes the comprehensive framework for PNM's requested approvals in this case. Is that the key language?
I'm sorry. No,
That is-
I think I'm on the wrong page of this. Mr.
I was looking at
Go ahead.
page 7 is what I was looking at.
Yeah, and I'm on that same page, and this is not what I was thinking we would. I know he discusses the standard on abandonment. You may have been looking at something different, Mr. Gifford.
No, I was looking on page 7, lines really 7 to 14 and 7 to 12. Does he set forth at least the company's understanding of how these statutes interrelate and interact?
He discusses about how the Energy Transition Act, that the Energy Transition Act is the standard under this for this application, and specifically 6218.4A provides that a financing order to obtain a financing order, that the utility must obtain abandonment approval, and that the financing order may be filed as part of the application. Yeah, so actually it wasn't that whole section, it's just that line 13 through 15.
Well, I won't pretend that we're going to stop troubling over this, Ms. Sanchez or Your Honor. But with that, I have no further redirect questions.
Okay, thank you. But I do see that the language that you talked about there, Mr. Gifford, it suggests that Mr. Fenton understands. I'm not going to suggest what he understands, but my reading of what he's saying is that the process for abandoning FCPP, abandoning Four Corners, and issuing a finance order, while abandoning FCPP precedes issuing a finance order. So that seems to suggest that a finding on abandonment is a necessary condition precedent to issuing a financing order. And I'll just observe that, my reading, and you can address it as you will in briefing. Thank you.
I will not rise to the temptation for oral argument. You would not, probably not permit that, Your Honor. So,
well, if at some point down the road, mark it for our discussion at the end of the hearing, so that I know what's coming my way at the appropriate time. And that's why I raise it now and flag it as I did with that long colloquy regarding that linkage, so-called, the actual troubling, both troubling issue and to trouble an issue that we need to deal with, I think. So that I just learned over time that I should start this dialogue and then circle back at the end of the hearing when I actually establish the parameters for briefing, that I'm actually addressing the correct, hopefully articulated issues. So thank you, Mr. President.
And if I have one last redirect question, if I do have time, Your Honor.
Yes, yes, sir, you do.
Ms. Sanchez, you had an opportunity to talk with Mr. Marks about prudence, and we know that prudence has a legal regulatory meaning. Could you give us what your understanding of prudence is?
Sure.
Mr. Maderos, I'm going to object. I asked her the question and she said she couldn't answer, and I let it go. I don't think if she answers now, and I won't have the opportunity to follow up on whatever she says, so I just think it's improper redirect.
Well, Mr. Gifford, if you ask the question and I allow her to answer it, I have to allow Mr. Marks to cross-examine her for up to 5 minutes on it. Do you want to ask that question?
Your Honor, we'll let that sleeping dog lie. Not that I don't like hearing from Mr. Marks, but we know we want to move along.
Great. Thank you, Mr. Gifford. Ms. Sanchez, thank you so much. I appreciate your testimony. You were great. Thank you.
Thank you, Mr. Hearing Examiner. Thank you, everybody.
You're excused. Okay. We're going to take 10 minutes, and that's our abbreviated morning break, and then we'll come back with Mr. Phillips in about 11:24. Thank you all.
When you're ready, Judge.
Yes, sir. Thank you, Mr. Lee. Morning, Ms. Terwilliger.
Morning, hearing examiner.
Is PNM prepared to call its next witness?
Yes. PNM calls Nicholas Phillips. May he be sworn?
Yes, please. Mr. Lee?
Yes, sir.
Would you please swear?
raise your
Ms.
right hand? You solemnly swear the testimony you're about to give in the matter now pending will be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
And Mr. Phillips, can you state your name and title for the record, please?
My name is Nicholas L. Phillips. I'm the Director of Integrated Resource Planning for Public Service Company of New Mexico.
And do you have before you what's been marked as PNM Exhibit 9?
Yes, I do.
Was PNM Exhibit 9 prepared by you or under your direction?
Yes, it was.
Do you have any corrections to that testimony?
Yes, I do. We had filed an errata that had made a number of corrections to my testimony, and all of those corrections had been made on the version that's been uploaded to Dropbox. I can go through those individually if the hearing examiner would like me to, and I do apologize. After the Dropbox version was loaded up, I found 2 other corrections. If we could make those, we have a version that can be uploaded immediately after to make sure that everybody has a final corrected version.
Let's do that then, Mr. Phillips.
Yes, sir. Would you like me to go through all of the errata changes one by one, or is the errata filing sufficient for that?
Are they marked in red line like some of the other PNM witnesses?
Yes, sir, they are.
Like for instance, on line 8, page 21, the median expected savings, median, MEDIAN, expected savings is approximately 143.7 million.
Yes, sir. Those are all marked. One of the additional corrections I noted was the exact same change you had just mentioned, just on a different page that was not marked.
Okay, the ones that are already marked and are reflected in the errata, we don't need to go through. Just please indicate the new ones.
Yes, sir. The first one is on page 3 at line 19, and it is the exact same correction you had just noted. The 142 million should be stricken, and it should be replaced with 143.7 million.
That's on line 19?
Yes, sir.
Okay.
And on page 11, line 21, the second and third word says combustion turbine. That should be stricken and replaced with commodity. So it should read commodity price forecasts.
I'm sorry.
Page 11.
Nanasi, could you just tell me where you are on page 11? What is the line?
Line 21.
Thank you.
And the change is instead
Combustion.
of,
Oh, I'm sorry.
Go ahead.
Combustion turbine should be stricken out and replaced with the word commodity. So between the 2 commas, it should read commodity price forecasts instead of combustion turbine price forecasts.
I'm sorry, between the 2 commas, it should read
Commodity price forecasts rather than combustion turbine price forecasts.
Are you saying priced, PRICED?
No D, just PRICE.
Good question, Mr. Lee. Thank you. Are there any others?
No, sir.
Okay.
With those corrections, Mr. Phillips, is your testimony true and correct to the best of your knowledge?
Yes, it is.
And if I asked you those same questions today, would your answers be the same?
Yes, they would.
I tender Mr. Phillips for cross-examination. Oh, I'm sorry. Can I, hearing examiner, may I move for the omission of PNM Exhibit 9, please?
Any objection? Subject to placing the fully corrected Phillips direct testimony in the appropriate place in the Dropbox folder to replace the version that did not contain these corrections. Yes, PNM Exhibit 9 is admitted.
Thank you, hearing examiner.
Thank you, Ms. Twilliger. Okay, we're ready for cross-examination of Ms. Phillips, starting with Bernalillo County. Mr. Albright, I have you down for 25 minutes. Do you still have 25 minutes with Mr. Phillips?
Mr. Medeiros, I would like to reduce that to 20 minutes and move 5 minutes from Mr. Phillips to Mr. Baker. So that would leave 20 minutes for Mr. Phillips and then 20 minutes for Mr. Baker.
Done. You have 20 minutes then with Mr. Phillips. Please proceed.
Thank you, sir.
You're
Good
welcome.
morning, Mr. Phillips.
Good morning.
Jeff Albright with J. Albright Law LLC, and I'm here this morning on behalf of Bernalillo County. So I would like to start off with a few basic questions that I have. If you would turn to page 2 of your direct testimony.
Yes, sir.
Exhibit 9. Several questions related to the resource planning. That's in the opening paragraph that you have there. Who makes up the integrated resource planning team?
I lead the team. There's currently 4 spots of individuals that directly report to me. That is Monique Ryman, Shane Gutierrez.
I'm sorry. If you could spell those names as you state them. Monique Ryman.
Monique Ryman, I believe it's R-I-E-M-A-N. It may be E-I. I'm not positive off the top of my head. The second name was Shane Gutierrez. The third name is Dean Brunton, B-R-U-N-T-O-N. Since we filed the integrated resource plan, Mr. Brunton has retired and we have not hired a replacement yet. The fourth name is Jeremy Heslop, H-E-S-L-O-P. Also, since filing the integrated resource plan, Mr. Heslop has transferred to another department within the generation organization. The integrated resource planning team does fall underneath the generation organization.
And who has final say with regard to the plan that your team puts together and that you obviously would approve with regard to submitting that to the Public Regulation Commission?
I report to Mr. Tom Falgren. He would review, as well as our executive policy committee would ensure that the integrated resource plan is consistent with the path of the company.
Okay, and when you say path of the company, it raises a question that I had related to rate cases. Do you coordinate the timing of your, I mean, I realize there's a requirement before the commission to submit the resource plans, but do you coordinate the issuance of the RFPs for the IRPs with the filing of a rate case?
There are no RFPs that are conducted prior to the issuance of an IRP.
So any affiliated companies or anyone else would not have any unfair advantage in that respect, correct?
Well, the action plan coming out of the integrated resource plan, if it identifies a resource need, would then lead to the issuance of an RFP.
Okay. And would you tell us that there was a little bit of discussion about the current status of the IRP that came up in some earlier testimony? Could you just provide where we're at in that process for this year's IRP?
We have already filed the IRP. We filed it on January 29th. Currently, the schedule, I believe, has alternative modeling for stakeholders, if they were conducting that, to be done by, I forget if it was August 31st or September 1st. Comments from stakeholders, I believe, are due to be filed on September 20th. A few weeks after that, PNM will file reply comments, and then shortly thereafter, the staff is supposed to make its recommendation regarding whether the IRP should be accepted. I don't recall the exact dates. I believe PNM's reply comments are somewhere around October 16th, and it's early November for the staff to file their recommendation.
And with regard to the integrated resource plan that you currently have, does that take into account the abandonment of Palo Verde, the proposed abandonment, the termination of the lease with the 114 megawatts in Palo Verde, and include the replacement resources for the Four Corners power plant? Does it include both of those?
I'd like to clarify the question a little bit, break it down into a few parts.
Sure.
The return of the 114 megawatts of leased interest in Palo Verde, as well as the abandonment of Four Corners, is included within the scenarios modeled for the integrated resource plan. However, the specific replacement resources will be identified in future filings. We've already filed the replacement resources for Palo Verde. We will file the replacement resources for Four Corners, as we've heard earlier in testimony, likely early Q1 next year. So we have some proxy replacement resources contained within the IRP. However, those may change when we get the actual RFPs evaluated and file the actual cases.
Okay, thank you for that, Mr. Phillips. Would you look at page 3, please?
Yes, sir.
And at line 7, well, beginning on line 5, you talk about the addition of replacement resources will, under the most likely cases PNM analyzed, result in cost savings for PNM's customers and a net public benefit. Did I quote that correctly?
I believe you read it correctly.
Okay, so my question is, under the most likely cases PNM analyzed, did you analyze other cases in which there was not a cost savings in PNM's customers?
No, all of the cases that we analyzed were presented in my testimony. Each of those cases demonstrated customer savings. The range of that customer savings varied from case to case.
Let me ask you to turn to what has been marked as Bernalillo County Exhibit 6 and is already in the record.
Okay. Just to clarify, I want to make sure I have the printed copy in front of me that's correct. This is a notice of annual meeting and proxy statement from PNM Resources.
That is correct. That's the correct document.
Yes, sir.
And Mr. Albright?
Yes, Mr. Hearing Examiner.
The document that's in front of Mr. Phillips may not have BC6 on it, but that doesn't change the document at all, right? That version.
That's correct, Mr. Hearing Examiner. The only change we had was making sure that the cover page had the correct label on it, which we had inadvertently omitted when we had filed it, but the documents are identical.
Thank you.
There is no change. So would you turn to page 1 of that document, please?
As it's labeled, page 1 at the bottom, or the
I'm
first
sorry, page 1 at the bottom.
Okay. I'm here with you.
All right, and in the second paragraph below, strategic combination with Avangrid, do you see that? It begins with consummation of the merger.
Sorry,
Strategic combination with Avangrid.
Continue, please.
Are you there, Mr. Phillips?
Yes, I am.
Okay. And in the first sentence, it states, and I'll just read it into the record here, consummation of the merger is subject to the satisfaction or waiver of certain customary closing conditions, including without limitation, the absence of any material adverse effect on PNMR the receipt of required regulatory approvals, the agreements relating to the divestiture of Four Corners being in full force and effect, and all applicable regulatory filings associated therewith being made. Did I correctly read that?
You correctly read that.
Okay, so my question with regard, with the IRP that you currently have out there that would be for replacement resources of Four Corners, would that be a material condition that would change in the event that abandonment is not approved?
Hearing examiner, I'm sorry, I would like to object to this question as outside the scope of Mr. Phillips' testimony. Some other PNM witnesses addressed the questions of the interrelationship of the merger in this case. Mr. Phillips did not address that.
And Mr. Hearing Examiner, this goes to the issue of his involvement with the IRPs and whether or not those would be a condition that would affect this provision, if he knows.
Then ask that question.
Yes, and that I thought that's what I had asked, whether or not the IRPs, if abandonment is not approved, whether or not the IRP would be a material condition that would be subject to this paragraph.
So I will first start out by saying this is the first time I've seen this document or read it, and I am not sure whether the abandonment being denied and whether that would change the integrated resource plan would be contained within the material adverse effect clause in this proxy statement.
Okay, thank you for that, Mr. Phillips. Would you turn to page 73, please, of the same document? And again, 73 at the bottom.
Yes, sir, I'm there.
Okay, the last paragraph talks extensively about IRP. So do you provide input into this proxy statement with respect to the IRPs?
I was not asked to provide any input into this proxy statement as far as I recall. Again, I've not read this, so this is the first time I'm seeing this.
Okay, at the bottom of that page, there's a statement that says, about 4 lines from the bottom, in PNM's 2016 rate case, PNM was required to evaluate early exits from the coal-fired FCPP in its 2020 IRP and to address the prudence of the FCPP investments in PNM's next rate case. Okay, do you see that language?
Yes, sir, I do.
Okay. Where would this information on IRPs come from who would input this into the record if you and your team don't input that into the proxy statement?
I would imagine that this could come from our regulatory group, just skimming through this paragraph. Most of this is very generic information that discusses consistency with the IRP requirements and regulatory filings.
Okay. And when it says the prudence of the FCPP investments in PNM's next rate case, are you aware of when the next PNM rate case is scheduled?
No, I'm not.
Oh, sorry.
You already answered.
Okay, and turning back to your direct testimony again, Mr. Phillips.
Yes, sir.
Okay, I just wanted to make sure we covered those. If you, again, back to page 3. You talk about, at line 9, about a portfolio of resources. Does that portfolio of resource include natural gas generation and quick start capability?
The exact replacement portfolio for Four Corners has not been
Sorry,
determined yet.
sir. I'm sorry, sir. I didn't understand what you first said.
Yes,
Can you
sir.
state it again?
Just need to slow down, Mr.
Yes, sir. The exact replacement portfolio for Four Corners has not been determined yet. We did examine later in my testimony two primary paths, which is consistent with the way we looked at our integrated resource plan. Some of those portfolios do contain natural gas, others do not. I should say new natural gas resources, others do not.
And I may be wrong, but I seem to recall, and this is just my recollection, was that about 83 megawatts of natural gas? Do you recall?
Or
let me rephrase the question. Where would you have that in your testimony?
Table NLP1, which is on page 27 of my testimony, shows the megawatt amounts of the proxy replacement portfolios.
Okay, thank you for that. Do you have an idea as to when the replacement portfolio IRP would be finalized? Proposed IRP would be finalized for the replacement resources for Four Corners power plant?
Can you clarify what you mean by IRP in that question? We are not planning to conduct a new IRP solely for the purposes of determining the Four Corners replacements. We will conduct a different analysis and file a standalone analysis.
Okay.
We are, to answer the specific question, the RFP that is being used to evaluate the Four Corners resources was issued on March 8th. We received the bids on June 7th. Mr. Falgren had testified that we've already gone through phase 1 and phase 2 evaluations. We are currently conducting phase 3. Ideally, we will be at a place where we know the likely set of resources early in the fourth quarter.
4 minutes, Mr. Albright, 4 minutes.
Thank you, Mr. Hearing Examiner. Do you have a sense for what the likelihood is of combustion turbine generation capability with regard to bringing hydrogen into the IRP mix is? Or let me restate that. In what you have, in any of the responses that you've received, has the conversion to hydrogen for the gas generation been in the mix?
Yes, it has.
And the timing on bringing those resources online, can you provide that, or would it be inappropriate at this stage of the evaluation for you to present that here?
I can say that generally the RFP has asked for all of the resources to come online by December 31st, 2024 or January 1, 2025, consistent with the abandonment taking place. That's not what is required for a new combustion turbine to be converted to burn hydrogen. That would just be when the initial resource would come online.
I see. Okay. On page 11 of your testimony, you refer to the description of proxy replacement portfolios. Would you just explain what that means? It's at line 2 on page 11.
Yes, the proxy replacement portfolio is a portfolio that was put together based on generic cost and operating characteristic data, similar to what we would do in the integrated resource plan. It is not based on specific bids from a competitive solicitation.
And how do you receive those? Where do those come into the process?
Where do we determine the cost and operating characteristics for the proxy replacements?
Yes.
We compile that from a number of different data sources. I believe I discussed that later in my testimony. So on page 16, beginning at line 15, I go through a discussion of how we populated the database of proxy replacement resources.
I had a question mark there as well. So thank you. I said, what is this? So thank you, Mr. Phillips, for that. And on page 19, at line 15, you have PNM's analysis assumed all undepreciated investments related to the Four Corners power plant assets were recovered via a securitization bonds, as more fully described by witness Baker. And so these replacement resources would be fully securitized, correct?
No, that's incorrect.
Incorrect.
The statement on line 19 refers to the securitization of undepreciated assets related to Four Corners. The replacement resources would go into the utility's cost of service, either in rate base or through the fuel clause, depending on whether they are utility-owned resources or done through PPAs.
Okay, and I appreciate that clarification. Thank you, Mr. Phillips. Mr. Hearing Examiner, that's all of my questions for Mr. Phillips. Again, Mr. Phillips, thank you very much for your answers. Appreciate it.
Thank you, Mr. Albright.
Thank you, Mr. Albright. Next up is community groups. Mr. Tisdale, I had you marked down for 10 minutes with Mr. Phillips. Is that still accurate?
That is. Thank you, Mr. Hearing Examiner.
Okay, please proceed.
Hello, Mr. Phillips. How are you?
I'm well, and how are you?
I'm doing okay. Thank you. Turn with me, if you will, to page 17 of your direct testimony. And in particular, I think lines 2 through 8. It reads, because the replacement resources for FCPP will likely remain in PNM's portfolio through 2040 and beyond, PNM limited the replacement alternative in this analysis to resources that may viably contribute to a carbon emission-free portfolio, including solar, wind, energy storage, and flexible combustion turbines resources under an expectation that new gas units would be converted to burn a non-carbon emitting fuel such as hydrogen by 2040. Did I read that correctly?
Yes, sir, you did.
So
Did
with
you say
respect,
2040?
I did, Mr. Lee, 2040.
Thank you.
So with respect to replacement resources, do you anticipate that PNM would seek an accelerated timeline for cost recovery on assets such as gas-fired turbines that by necessity must have a shorter operational life to comply with the state's decarbonization requirements?
I don't agree with the premise that they necessarily have to have a shorter operational life. What the statement you read from my testimony indicates is that if there was a new combustion turbine added in the modeling, it was assumed to be able to convert to burn a non-carbon emitting fuel by 2040 and thus operate beyond 2040.
Okay. So I'm interested in the idea of the gas turbine conversion to hydrogen. And I assume that you have a general understanding of hydrogen. Is that correct?
Yes, that's correct.
And this is a fuel that is produced. It's not mined like coal or drilled for like natural gas. Is that correct?
Yes, that's correct.
And there are different processes that can be employed to produce hydrogen. Is that correct?
Yes, that is correct.
So when you speak of hydrogen here in your testimony, what is the type of hydrogen that you anticipate PNM using?
We did not make a distinction specifically with respect to whether it would be what's known as green or blue hydrogen, being the process of electrolyzing water and then storing hydrogen on site versus steam methane extraction for hydrogen. The assumption that we had made was that the hydrogen would be delivered and could be combusted through the turbines as a zero carbon emitting fuel, but we did not allow that resource to count towards our renewable portfolio standards. So we weren't trying to make the statement that this is a renewable resource. It is PNM's position that we would prefer to be able to procure green hydrogen. And if we could produce that on site, or whether it would have a hydrogen industry and broad scale deliveries similar to what natural gas has done now, that would also be preferable. But we would seek green hydrogen when possible.
There's a veritable rainbow of different types of hydrogen, right?
That's correct.
So you're aware that common today is what is called gray hydrogen, and that is used in industrial processes. And gray hydrogen is derived from natural gas. Is that correct?
I'm not as familiar with gray hydrogen. I believe that's correct, but I'll take your word for it.
Okay. And are you aware that the production of hydrogen derived from natural gas results in vast amounts of CO2 emissions?
I know that CO2 emissions occur. I don't know that I would characterize it as vast.
Okay. And so-called blue hydrogen is essentially the same process being derived from natural gas, but it involves the addition of carbon sequestration technology. Is that correct?
That's correct.
And are you aware that even if carbon sequestration is used, that there are still significant fugitive and production-related emissions, and that the overall carbon footprint of the fuel source does not necessarily meaningfully improve relative to a gas-fired turbine?
I don't know that for a fact. When you combust hydrogen through a turbine, it is a zero carbon emitting fuel. That's what's required under the Energy Transition Act. I do believe what you're referring to would be more life cycle emissions.
That's exactly where I'm going. So do you think it would be important to consider those hydrogen production related emissions when determining if we are meeting the renewable portfolio standard requirements for New Mexico?
I believe that the legal definition under the renewable portfolio standard only considers the direct emissions during the conversion process from fuel to power and does not consider life cycle emissions.
Okay. Would you agree that the goal of the RPS is to decarbonize energy generation in New Mexico?
Yes, I would.
So if we're simply moving those emissions to an earlier stage, but those emissions still exist, would that not defeat the ultimate goal of addressing the climate crisis?
I would disagree with that. Every single type of resource now has a life cycle carbon emission. Solar, wind, when you're mining, especially if those mines are in China where they're using predominantly coal-fired generation, you're going to have life cycle emissions when you're extracting the raw materials, then you've got to ship them over, et cetera, et cetera, et cetera. So I think every single resource out there has its own difficulties. The purpose of the renewable portfolio standard is to ensure that there's a reduced and eventually zero carbon emission coming from the conversion of some fuel or other source into electricity.
I totally agree with you that the life cycle emissions for any energy generating resource are vast. We just sort of went through the process of how hydrogen is produced. And what we're talking about here is really, it's one step away. We're not talking about needing to go back to the mining of different sources in China or the shipment over. We are talking about just simply one step away. So you're saying that for purposes of the RPS, the only thing that is counted is those tail end emissions of what is actually combusted in the turbine. And I'm simply asking, if we go one step before that, are not those emissions still relevant to New Mexico meeting its decarbonization goals?
Not the way that the Energy Transition Act and the amended Renewable Energy Act are written. No.
Okay. Do you include a chart in your direct testimony at page 29?
2 minutes, Mr. Tisdale. Sorry to interrupt you, but I just wanted to give you that warning.
Thank you, Mr. Hearing Examiner. And this chart is regarding the PNM system carbon intensity. Is that correct?
Yes, sir, it is.
So whether we're talking about gas or hydrogen turbines, life cycle emissions are not included in your calculations for the carbon impact of these resources. Is that correct?
These are direct emissions from the conversion into electricity. So no, it's not a life cycle emission calculation.
And relative to the emission reductions benefits that PNM identifies from the Four Corners seasonal operating agreement, how would those emission benefits change if life cycle emissions were included in your calculations?
That's not an analysis that I have performed.
Do you think that they would change at all?
I believe the 20 to 25% figure referenced by Mr. Falgren is the direct emissions output for the plant. So that would still remain the same.
Even if we included life cycle emissions?
But his calculus was about the direct emissions resulting from the conversion of coal through the steam turbines and production of electricity. That number would remain unchanged.
Yeah, but I'm talking about the relative benefits of the seasonal operating agreement if life cycle emissions were included.
I think that the seasonal operating agreement, just as it reduces the direct emissions, would also reduce the life cycle emissions.
Okay, one last question for you, Mr. Phillips. So relative to the net public benefit standard applied in this case, do you agree that health and environmental impacts of emissions from either direct combustion or fuel production on local communities and individuals should be considered?
I think that is something that should go into the calculus. And if we look at the proposed transaction, the reduction in both PNM system as well as overall emissions from the plant being reduced is a benefit.
Okay, thank you so much, Mr. Phillips. I appreciate your answers today.
Thank you.
Thank you, Ms. Sorry. Thank you, Mr. Tisdale. Ms. Manazi, New Energy Economy, I have you with down for 15 minutes. Do you still have 15 minutes for Mr. Phillips?
Excuse me. Yes, sir.
Okay, please proceed.
Good morning, Mr. Phillips.
Good morning.
Could you go to your directed page 6, please?
I'm there with you.
On around line 17, you state here that PNM systems should be in a better position to reliably manage the transition required by the ETA. Are you referencing here the requirements included in the ETA to meet certain renewable energy targets?
Sorry, let me read the sentence real quick. The purpose of what I've written here discusses that the removal of a less flexible resource and being replaced with more flexible resources will further our ability to ensure the delivery of renewable resources.
And on page 8, you also talk about that on line 9. And here, you're still in that same sort of discussion about being able to have a reliable service and to have more flexibility. But you're also saying here, are you not, that it's important to meet the renewable portfolio standard that's prescribed, as you say, by the ETA. Is that correct?
So again, here I'm also talking about the additional flexibility. We would, as I testified to later in my testimony on page 25, even without going through the abandonment, we would still be able to meet all of our requirements under the Renewable Portfolio Standard as amended by the Energy Transition Act. It will be easier to do when you have a more flexible system.
From page 11 to 20, you discussed the modeling that you performed and the key assumptions you made, correct?
Section 3 is called the Four Corners Power Plant Abandonment Analysis and does discuss a number of those things.
When did you begin the performance of this financial and reliability modeling for replacement power in earnest?
We have just begun the replacement power analysis. This section in my testimony discusses the abandonment analysis.
When you say just now, could you just give us a date or around a date?
The RFP that was issued that will determine replacement resources was issued on March 8th. We received the bids back on June 7th. Beginning when we got the bids back, we started the phase 1 and phase 2 evaluations. We just, I believe it was August 23rd of this year, moved into the preliminary stages of phase 3 evaluation, which is the portfolio modeling that will lead to the replacement portfolio.
Could you go to page 19? And I'm going to ask you something about the same thing that Mr. Albright asked. And so here you state that on line 15, that in every analysis thus far that you've conducted, it assumed all undepreciated investments related to Four Corners assets. Is that correct?
Yes, it states that PNM's analysis assumed all undepreciated investments related to the Four Corners power plant assets were recovered via securitization bonds. And that was through every scenario.
And that means that if the commission denied some or all of the undepreciated investments as imprudent, then customer savings would be even greater than what you have projected. Is that correct?
I don't know that we can make that leap.
I'm asking you to do that.
You would need to apply that to both sides of the equation because you have a with case where Four Corners goes through 2031 and without case when Four Corners goes through 2024. And if the same amount comes off both sides, the customer savings may be the same. The customer savings is a delta between two cases.
Well, let's say that the commission denied some of the undepreciated investments. Is that right? And then in the but approved abandonment, there would be a cost for replacement power, but the company would not get as much money back for its undepreciated investments. In that scenario, would customers save even more money?
And I'm saying that the hypothetical lacks definition for the other side of the equation. In the case where Four Corners would stay in PNM's portfolio through 2031, are you hypothesizing?
I'm sorry, in the case that?
In the case that Four Corners stays in PNM's portfolio through 2031, are you suggesting that there would not be a write-off? That doesn't make sense to me.
Well, there might be a write-off. But
which is why I can't answer the question, because I have to have assumptions on both sides of the equation.
So let me ask you to assume this, that some or all of the undepreciated investments are reduced. The commission allows for PNM up to abandon, and the replacement power resources are exactly the same as they were beforehand. Customers would save more money. Is that correct?
Hearing examiner, I'm going to object. I believe this is the exact same question, scenario that Ms. Manasi, put forth just a few minutes ago in cross-examination. So asked and answered.
Mr. Phillips, you were going to say?
The customer savings calculation is a difference between two cases. You've got a case where Four Corners goes through 2031 and a case where Four Corners goes through 2024. You're only telling me an assumption about the 2024 case. I would question why that wouldn't be the same assumption you would make if Four Corners stays in the portfolio through 2031. Therefore, I can't, without that assumption being known, I would say that they should be equal, and that means that the customer savings don't change.
But sir, I did say that the abandonment would take place. Let's say it's abandonment as of 2024, as the company has proposed. So all I'm asking you really is, there's no change on replacement power. The only difference is that there would be a difference to customers about having to be obligated to pay those undepreciated investments or not. And you say here that in all your assumptions, you assumed that undepreciated investments would be fully recovered. Did you do any, did you run any analysis that didn't include all of that?
I've already answered that question and said that the analysis, both in terms of when Four Corners would come out in 2031 and when Four Corners would come out in 2024, assumed full recovery of undepreciated investments.
Can you go to page 27? So here you're talking about the kinds of replacement power that you looked at thus far for Four Corners. And one of those scenarios includes 360 megawatts of flexible combustion turbine resources. Is that correct?
The statement that you're referring to on lines 1 and 2 discusses the time period 2023 through 2025. So the 360 megawatts of flexible combustion turbine resources would not be dedicated specifically as replacement resources, proxy replacement resources for Four Corners, but could also be a part of the Palo Verde replacements.
Well, the company has already stated what the Palo Verde replacement resources are. I know it hasn't been approved, but you are aware that no one has objected to those replacement resources, and they do not include flexible combustion turbine.
Correct. That's correct. This testimony was filed prior to us filing the replacement resources for Palo Verde. These were proxies. There's another portfolio that shows no combustion turbine resources coming in. We won't know the exact portfolio until we file that replacement resource case for Four Corners.
I'm sorry, won't know.
We won't know the exact replacement portfolio until we file the Four Corners replacement resource case. This was giving an idea on one side of the equation for if you allow new combustion turbines for the 23 to 25 time period, what might look like. And there's another side that shows what it looks like without any combustion turbines. In Palo Verde, there was no combustion turbines, as you indicated.
5 minutes, Ms. Nazi.
Thank you. Is PNM considering the conversion to hydrogen from the Palo Verde plant?
What do you mean the conversion of hydrogen from the Palo Verde plant?
Are there any plans to convert the Palo Verde plant?
The Palo Verde plant is a nuclear resource. You could posit that in times of oversupply, it could be used to produce hydrogen, but that would not mean the plant runs on hydrogen. That's where I'm a little confused.
Okay. Would PNM request a depreciation timeline to go beyond 2040 in anticipation that the flexible combustion turbines would be converted to hydrogen?
I don't know the answer to that question. That would be better for Mr. Baker. I can say in the modeling conducted, we assumed perfect foresight that hydrogen would be available in 2040, and thus the units would operate beyond 2040. And so the depreciation schedule within our modeling assumed a 40-year life for the combustion turbines.
But hydrogen is not being used at all by PNM at this time, is that right?
That's correct.
On page 29, your NLP4, this graph demonstrates the possible PNM system carbon intensity options consistent with the targets set forth in the Renewable Energy Act included in the ETA. Is that right?
I'm sorry, can you say the question one more time?
This graph demonstrates the possible PNM system carbon intensity options consistent with the targets set forth in the Renewable Energy Act included in the ETA. Is that correct?
I don't understand what you mean by the carbon intensity options. What this plot shows are the requirements under the ETA section 10D that go into effect because PNM took the financing order in the San Juan case, shows the 2040 carbon-free goal that PNM has set as a corporation, and shows how we can meet all of those goals with or without Four Corners in the portfolio 2025 versus 2031, and demonstrates the significant reduction in carbon emission intensity when Four Corners comes out early.
If Four Corners were to stay in, would that require PNM to use renewable energy credits to meet those goals?
You cannot use a renewable energy credit to reduce carbon on the system. A credit is a piece of paper.
Right, I know, but I'm talking about to meet the RPS standard.
So the only way to meet the RPS standard is to retire RECs. The ETA requires that all RECs,
to retire.
renewable energy credits, what is known as a REC, REC. The Energy Transition Act has included in its legislation that all RECs must be bundled with energy. So you are not allowed to just use paper RECs.
Okay, so is it because, how does PNM meet the carbon or the RPS requirements with keeping in Four Corners? Is it because it's adding so many megawatts of renewable energy?
The renewable portfolio standards change over time, as well as you got the carbon emission intensity requirements that change over time. We would be adding additional renewable resources, such as those coming from the San Juan replacements and the Palo Verde replacements. The addition of those renewable resources would allow us to meet our RPS and actually exceed the RPS well in advance of some of the interim requirements that come on in 2025 and 2030.
Okay, could you go to page 30 and could you read?
Got about 4 seconds.
Could you read that sentence then?
Thank you, Ms. Nazi. We're done. We've got to move on. Thank you. I don't know why you kept reading after I said what I said. Did you not hear me, Ms. Nazi?
I'm sorry.
Again, a slight bit of respect would be helpful. For future reference, at least. Thank you. Attorney General, Mr. Elliott, you have 10 minutes. Do you still want 10 minutes with Ms. Phillips?
I want 5 minutes with Mr. Phillips.
Done.
Thank you. Thank you very much. And if I may, I'd like to reallocate some of that time.
Yes.
Okay.
Go ahead.
You very much. Mr. Phillips, thank you. I just wanted to follow up regarding the RFP for the replacement resources. So you said that it's the RFP was issued March 8th and you got your responses back June 7th, right?
That's correct.
Okay. And PNM will not be issuing a second RFP for the replacement resources. Is that right?
We have no plans to issue a second RFP at this time.
Okay. And you're aware that there's the merger docket, correct?
I'm aware there was a merger docket. I had no role in it.
Okay. Have you had an opportunity? Are you aware that there were certain regulatory commitments made as concessions?
I'm generally aware of them, not specifically aware of each one.
Okay. Are you generally aware that one of them is that PNM commits to using an independent evaluator?
I am generally aware that that is a commitment. I forget which number, but I've seen it.
Okay. I think for the record, it's number 34.
That sounds right.
Okay. This RFP would not be subject to an independent evaluator, right?
We are using an independent evaluator for this RFP.
You are?
Yes, sir.
Okay. Would you mind telling us the name of the independent evaluator?
Bates White Economic Consulting.
Okay. And could you direct me, is that in your testimony?
No, we had not issued the RFP at the time that this testimony was filed.
Okay.
We've actually coordinated with two different potential independent evaluators, the other being Merrimack, which I know the commission does like and is used by EPA, I believe. Unfortunately, they were not able to join on this task that quickly. So we also contracted with Bates White.
Okay. And when was that decision made to use an independent evaluator?
Right about the same time we made the regulatory commitment, and I saw it in the stipulation agreement that was filed with the commission.
Oh, okay. But in crafting, that was after the RFP was crafted, correct?
That's correct.
Okay. That's all my questions. Thank you, Mr. Hearing Examiner. Thank you.
Welcome.
Appreciate it.
Thank you, Mr. Elliott. For future reference, if you're at the end of your time and you simply ignore the hearing examiner and ask the next question, odds are you're not going to be allowed to ask the next question. If, however, you respectfully request leave, I might consider the ability to ask that question after your time has elapsed. So next up is Mr. Gerhardt for Sierra Club. You have 45 minutes. Now, I suggest that we take, it's a little, I indicated that we we're going to have an abbreviated 15-minute lunch break because we have to finish at 2 p.m. or approximately 2 p.m. today. So I suggest that we break now unless there's another cross-examining party after Sierra Club, like for instance, Ms. Beatles, you have 10 minutes scheduled with Mr. Phillips. Would you be prepared to go now or would you like to wait until after Mr. Gerhardt? Same goes for Water Utility Authority and staff. I'm just trying to slot a few minutes in here if possible. If not, if that's inconvenient, I apologize. We'll just go to the 15-minute break now. Ms. Beatles?
I'm prepared to go now.
Would you mind, Mr. Gerhardt, being moved back until after the lunch break?
Not at all.
Thank you, sir. Okay. Thank you so much, Ms. Beatles, for this accommodation. You have 10 minutes with Mr. Phillips.
Of course. Good afternoon, Mr. Phillips.
Good afternoon.
So I'm sure you're aware, aren't you, of the recent delays in the San Juan replacement resources, right?
Yes, I'm aware.
Are you still confident that adequate replacement resources will be available if and when PNM exits Four Corners about 3 years from now?
Yes, I am.
Okay, so could you please explain that response? Please reconcile that with the unexpected delays that PNM is facing with respect to I don't know what
PNM
just
is
happened.
facing.
Ms. Zerd muted herself immediately. Go ahead.
Okay. Please reconcile that response in the face of the unexpected delays in the San Juan replacement resources.
Sure. I think there's a number of things that I would consider. The first is that this case has a much longer lead time prior to when the replacement resources would need to come online. If we file the replacement case, say first quarter of next year, let's just use a date of January 8th. Not saying that's going to be the exact date, but that's a year from when we originally made the filing in this docket. Assuming about that time, even if there was a CCN required and the commission took the additional 6 months beyond the 9 months that it was allowed, we would reasonably expect an order by the end of April of 2023. And you'd still have the better part of 2 years to bring the replacement resources online by the beginning of January 2025. And the critical time period would actually be the peak in the summer of 2025. So it's a much longer lead time. A lot of the delays right now are really—
I'm sorry, if you could slow down a little bit, a much longer
lead time than was given for the San Juan resources to come online. And a lot of the delays are mainly related to the condensed time frame in conjunction with the COVID supply chain issues and some developers still needing to get financing and other things taken care of, land. So the additional time will help this. We have the RFP already underway. The contracting can be done in a more succinct and more secure way when we contract for these resources. We've been talking to developers as well as other folks, and the COVID supply chain issues are expected to be, a short-term blip, not a long-term effect. So, those are a number of the reasons why we fully expect that, assuming we stick to the schedules, that we will be able to have sufficient replacement resources online in time.
So you just referred to discussions with the developers that are the basis of your expectation that this will be a short-term blip as opposed to a long-term delay. And does that include discussions with the 8-Minute Energy developer?
We had discussions with the 8-Minute Energy developer as it relates to their contract. My reference to developers in my preceding answer was generally talking to folks in the development community about specifically how they are looking at the COVID supply chain issues.
So you weren't referring specifically to discussions with the developers of the specific San Juan replacement projects, including 8-Minute Energy, San Juan Solar, and Centaurus or Arroyo Solar?
We have discussions with each of those developers to get updates on their projects and find out what's going on. We also have discussions with the general developer community to discuss, what they are seeing in terms of supply chain issues to make sure that we're not going to repeat these issues.
Okay. So not referring to discussions with the general community, but to discussions with the developers of the specific San Juan replacement resources. Do those include discussions with the developers with the 8-Minute Energy developer?
There have been discussions with that developer. I have not personally had those discussions. I just know that those discussions have been had.
Are the delays associated with that particular project expected to be a short blip or more long-term?
Those delays are not related to the COVID supply chains.
Are they short-term or long-term?
That's still being worked out between Mr. Falgren and the developer.
So you don't know, is that right?
I do not know.
Okay. In response to questions by Mr. Albright, you referred him to page 16 with respect to how you developed your proxy portfolio. Is that right?
I recall that discussion.
And you referred him to page 16, right, of your direct testimony?
He asked specifically how we determine the cost and operating assumptions for the proxy resources. That's what I referred him to there, not the development of the portfolio.
Okay, thank you. So the cost and operating characteristic assumptions. So let me ask you how your database of proxy replacement resources was populated. Specifically, I want to know the source of your generic cost information.
It was taken from a number of different sources, as I've indicated in this response.
Yeah, but I'm asking you specifically, was the source primarily responses to your 2017 RFP?
And my answer is that there was a number of different sources that we looked at. Some of it was from the 2017 RFP. Some of it was from the NREL and EIA databases. We also
I'm
compared
sorry,
it to
some of it was from the NREL.
the NREL, National Renewable Energy Laboratory, NREL database, known as the Annual Technology Baseline. Another was from the Energy Information Administration, EIA, Annual Energy Outlook, as well as we did a sanity check against the Palo Verde RFP, the 2020 RFP.
The data you got from NREL and EIA were trending assumptions, right?
They also contained cost assumptions for variable and fixed O&M. So we used a number of different sources.
Right. So the 2017 RFP, NREL, US EIA, and also your Palo Verde RFP responses, right?
Yes.
Okay, thank you. And the information you got from NREL and EIA was trending, and you're saying also some other cost assumptions.
There's multiple cost assumptions that go into defining the proxy replacement resources. The NREL database was used to determine the technology cost curve. So it would have influences on capital cost, fixed O&M, and variable O&M over time. For some of the resources, my recollection, I'd have to go back and look specifically, is that we used the EIA's database for some of the capital cost, fixed O&M, and variable O&M. For other resources,
EIA database
Slow down.
Yep, I'm sorry. Yes, the EIA database for capital cost, fixed O&M, and variable O&M assumptions, as well as we utilized our 2017 RFP and the 2020 RFP as a sanity check.
Okay, so I was not asking about multiple sources. My last question was about what specifically you got from NREL and EIA. And I believe your response is cost curve data.
No, I don't believe that's what I said. I said for the NREL annual technology baseline, that was predominantly cost curve going forward, but that would influence the capital cost, fixed O&M, and variable O&M cost on a going forward basis. For the EIA, I do believe that there were some values for variable O&M and fixed O&M. I don't recall on the capital cost that influenced the specific starting points.
Mr. Hearing Examiner, I have one more question. Do I have time for that?
Yes, you have 1 minute.
Okay, thank you. So, Mr. Phillips, if the commission denies abandonment because PNM has not shown with sufficient certainty that adequate replacement resources will be available upon abandonment, when would PNM be ready to file an application that includes an actual portfolio with specific resources?
So I believe that PNM has shown that there will be adequate replacement resources available. We already have an RFP with significant amounts of power bid into it, with pricing that is very much in line with the last 2 RFPs we issued. And those pricing and bids have to remain valid through April 1st, 2023. So I don't think there's an issue there, but we are planning on filing a replacement resource case with this RFP information used as the evaluation criteria for replacement resources the first quarter of 2022.
So just to confirm, if the commission denies this case, PNM would be ready to file a consolidated application that includes an actual portfolio with specific resources by first quarter 2022?
I don't know when PNM would be able to file such a hypothetical case. My statement is that we have demonstrated specifically that there is adequate replacement power available, and we will be filing a case based on the RFP that's utilized to that demonstrates that availability the first quarter of next year.
Do you know of any reason why that?
This is a second follow-up question, Ms. Beatles.
I'm sorry, but I'm trying to get a response that is, trying to get an answer that's more responsive to my question. Are you aware of any reason, Mr. Phillips, why that replacement case could not be combined with the other components of a consolidated application that includes abandonment and securitization?
Because that case has already been filed. That's what we're adjudicating right now.
If it gets denied, Mr. Phillips?
I'm not in charge of case filing strategy.
So
I don't know.
So you don't know?
I do not know.
But are you aware of any reason why it could not be combined?
Objection, asked and answered. I think Mr. Phillips has given the answers he felt like he could give.
Overruled.
I am not aware of any reason. That's not my department's purview.
All right, thank you. That's all.
Okay, thanks, Ms. Beatles. We're going to go to break, but before I do, I want to mention another teachable moment. Ordinarily, I try and give 5-minute warnings or 4-minute warnings, but I didn't feel like I could insert myself without interrupting the flow of the Q&A. And so just have to bear with me on that I don't want to interrupt. If I feel like I can interrupt the Q&A, I'm not going to insert myself and give a warning. So that's what just happened with Ms. Beatles and Mr. Phillips. So with that observation, I try and stay aware. I'm trying to give the warning when I can, but I just felt like I couldn't insert myself and not interrupt the flow. So with that, we're on a 15-minute break. We'll be back at approximately 12:50. Let's see. About then, about 12:50 or so, we'll come back and we'll start up with Mr. Gerhardt again. Thank you all. Have a good abbreviated lunch break.
Man, he was flying. How fast do you think he was talking?
I have no idea.
David, you're not muted.
Thank you.
Mr. Lee, this is Matt Gerhardt. Can you hear me?
Yes, sir.
Okay, great. I just wanted to check my audio.
All right, patience your rhythm because the witness speaks fast.
I will try to slow down.
You know, I don't blame you because if it's your habit to speak quick, it's a really hard habit to break. It's just that you're using multisyllabic words in your statements and it's hard to make the finger transition from one to the next, or it can be. I'm keeping up for the most part. I only interrupt when I'm not.
Well, I do apologize. I've added a third sticky note that says slow down.
Don't worry about it, my friend.
Thank you, sir.
For what it's worth, it's easier for the lawyers to slow down, or at least I think so, because we can plan in advance what we're going to say. You have to respond. You don't know what we're going to say.
Exactly. Thank you, Mr. Borman.
But if you do slow down, that, given the time constraints we're under, that does limit the cross-examination. Not giving you any bright ideas there. All right, thank you all. We're back from our abbreviated lunch break. And I believe Mr. Garrett.
Mr. Medeiros, may I just interject here? I'm scheduled for, I believe, 15 minutes with Mr. Phillips, but I will not be using that time.
Okay. Thank you, Mr. Borman.
Yes.
Appreciate that. So with that, after Mr. Gerhardt for Sierra Club will have the Water Utility Authority for 20 minutes. But right now, and thank you again, Mr. Gerhardt, for allowing yourself to be bumped to fit that time in before the lunch break. But now it's your turn and you have 45 minutes. Do you still have that amount of time with Mr. Phillips?
Yes, sir.
All right, thank you. Please proceed.
I'll certainly try to use less if I can, but I may need the full 45. Good afternoon, Mr. Phillips.
Good afternoon.
Would you please turn to PNM Exhibit 9? That's your direct testimony, to page 3, line 2. And please let me know when you're there.
I'm here with you.
Okay. So you state PNM conducted a thorough resource planning analysis of whether to retain the FCPP assets. Do you see that?
Yes, I do.
My understanding is you used an energy system model in
I'm
Compass
sorry,
to
Mr.
conduct your
Gerhardt.
analysis.
I'm sorry, Mr. Gerhardt, you broke up. My understanding is you used
An energy system model called Encompass to conduct your analysis.
I believe you said, did I use Encompass to conduct my analysis? The feed is getting a little choppy.
Yes, that's the question, Mr. Phillips.
Yes, that's correct. We used a system capacity optimization and production cost model called Encompass.
If you had not used an energy system model like Encompass, would you consider your analysis to be a thorough resource planning analysis?
I think that you have to consider what you're trying to analyze and what you're trying to do. Preferably is to use a system optimization model such as Encompass. There may be times when alternative methods are appropriate.
Just for a clarifying question, for the purpose you had here, which was to compare two different scenarios, right? A 2024 exit, a 2031 exit. Do you think that using a model like Encompass is the optimal methodology?
Again, I would say that that is the preferred methodology for performing an IRP or some type of forward-looking resource planning decision. There may be times where other methods are appropriate, but the preferred method would be the system modeling.
Thank you. My understanding is that in your analysis, you included the forecasted capital costs of resources in both the 2024 and 2031 exit scenarios. Is that right?
The feed is still breaking up a little bit. Which capital costs are you referring to?
I'm asking about the forecasted capital costs for the analysis period for both the 2024 and 2031 exit scenarios.
And so are you referring to capital costs for the new resources, capital costs for existing resources, like ongoing capital costs, or just all capital costs?
All of them.
Yes, we did.
Okay. Had you omitted capital costs from your analysis, would you consider your analysis to be thorough?
I think that depends on which capital costs. If the capital costs were the same, such as an existing resource that has the same capital costs included over the entire study horizon, omitting that capital cost would not change the delta between two places. So it would not be material whether it was in or out. If it was something that changes between two scenarios, then it would be improper not to have that included.
Thank you. So in your analysis, you're comparing a 2024 exit to a 2031 exit of Four Corners, correct?
Yes, that's correct.
You didn't compare any. Oh, sorry.
I guess one bit of clarification: the 2031 exit is assumed to be a plant shutdown, so it's got reducing capital expenditures moving into the retirement. So it's not, the exact same as just PNM exits, but the plant continues to operate.
Thank you. My question is, did you model any other exit dates besides 2024 and 2031?
No, we modeled the proposed transaction.
So I want to try to clarify some things that you discussed with Ms. Nnazi around assumptions around recovery of undepreciated Four Corners costs. And I'm just trying to understand what you did. So in the scenario in which PNM exits Four Corners in 2031, you assumed there's no future disallowance of undepreciated Four Corners costs. Is that right?
The 2031 capital recovery, the plant is being used and is useful for PNM system. There's no assumed write-offs or any disallowances other than the existing debt-only return applied pursuant to the 2016 rate case. It was traditional capital recovery through ordinary rate of return depreciation. It's an O&M recovery through cost of service through 2031. There still would be a
Mr.
small...
Phillips is starting to go fast again.
I apologize.
And it's with the jargon laden testimony that it tends to speed up, which is the worst time. But go ahead. For the court reporter.
Let me start over. So for the 2031 scenario, we assumed traditional recovery of our cost of service for the remaining net book value through depreciation, rate of return, operation and maintenance expense recovery, including the debt-only return as laid out in the 2016 rate case order. There would still be some small amounts of undepreciated investments in Four Corners at the time the plant would be taken out of service in 2031. those costs were assumed to be securitized under the Energy Transition Act.
Thank you, Mr. Phillips. What I'm trying to pin down and clarify is, in your modeling, there's no modeling run in which you assumed that this pending application is denied, and then the Four Corners undepreciated costs from the 2016 rate case are disallowed. Is that correct, that that scenario wasn't a part of any of your modeling?
That scenario was not a part of my modeling.
Okay, thank you. So moving on to the cost deltas between the two exit scenarios. So under the 2024 exit scenario, PNM continues to pay its share of Four Corners costs through the end of 2024. Is that right?
I'm sorry, the feed broke up a little bit.
Sorry, I'll repeat that. I apologize. So in the 2024 exit scenario that you modeled, PNM continues to pay its share of Four Corners costs through the end of 2024, right?
That's correct. The costs and operations of Four Corners through the end of 2024 remain exactly the same through PNM's eyes.
Okay, so in terms of cost deltas between the two scenarios, you won't see any cost deltas until 2025. Is that right?
There could be small deltas, but nothing material.
Okay, so when you talk in your testimony about the cost savings from the 2024 exit, those are savings that would mostly be realized after 2024, right?
The majority of the cost deltas and savings would be passed through to customers between 2025 and 2031, the time period in which Four Corners would have been in the portfolio, but is no longer in the portfolio. There could be minor differences in other years, but the majority of the savings would accrue in those years.
Okay, thank you. Would you turn back to your direct testimony to page 23 and let me know when you're there, please?
I'm there.
Okay. So I want to try to confirm my understanding of this figure on the top of the page. So my understanding is this is a graph of the incremental savings from the 2024 exit relative to the 2031 exit that you modeled. Is that right?
Yes, that's correct.
Okay. And that dashed vertical line is the median savings from all the different replacement resource portfolios you modeled. Is that accurate?
That's correct. The dashed line is the 50th percentile of the solid black line, the fitted curve, to either roughly 32, I believe it was, different cases that we ran, with and without the proposed transaction.
Okay. So is it accurate that if you look at where the no new combustion portfolios fall relative to the median, that most of the no new combustion portfolios are to the right of the median savings?
I don't know that I can agree that most of them are necessarily to the right. I can agree with you that the no new combustion cases tend to produce smaller customer savings compared to the technology neutral cases. and say that an equivalent technology neutral case, all else held equal.
Okay. Do you know whether you ever calculated the median savings of just the no new combustion portfolios?
That was not a calculation I had ever performed.
Okay. Looking at this figure, would you expect that median of the no new combustion resources to be less than the median shown here?
It would be tough to say without performing the analysis, given the technology neutral cases tend to be a bit higher customer savings. If you were to remove those, I would expect the median to be slightly lower than what's listed here. Although every single case we looked at did still show customer savings.
Thank you. As we just talked about, as we talked about before, the exit dates you modeled were 2024 and 2031, right?
Yes, sir, that's correct.
Okay, so have you modeled in either this case or another case PNM exiting Four Corners in 2028?
That's not analysis that has been performed under my direction. Okay. I don't know that it's been done prior to me coming on in my role here. I talked with my team about it. I don't believe it has, but I know it hasn't been performed under my direction.
Thank you. In this case, did you present an analysis of exiting Four Corners in 2024 by breaching PNM's current contractual obligations under the Four Corners agreements?
No, again, we performed an analysis that represented the proposed transaction that's on the table. My understanding is that had PNM's obligations or had PNM exited without the proposed transaction, it would remain on the hook for the vast majority of costs, and thus they would eliminate any potential customer benefit.
Hearing examiner, can I just interrupt? I'm missing some of Mr. Gerhardt's words, and since words matter here, I don't know if Mr. Phillips is experiencing some of the delay. Maybe the court reporter is getting them, but I wasn't sure that last question. I got all the words correctly or understood them.
Looking at the real-time transcript, I think he did capture them, but there have been some difficulties, but I think the last one came through. Okay. Mr. Phillips, did you understand the question?
Yes,
did you
I
hear
understood
all the words?
Yes, sir. I understood it to be.
My bad. Sorry.
Okay. I understood the question to be, did we model a scenario where PNM exits in 2024 and basically broke the terms of the contract?
I just wanted to check, Mr. Hearing Examiner.
Thank you, Mr. Williger. If you do have trouble, Mr. Williger, going forward, just please let us know.
Okay, thank you.
Go ahead, Mr.
And thank you. And I apologize if anyone can't hear me. Please let me know and I'll repeat a question.
Look, it looks like we shouldn't pause you again because the pause tends to slow down the feed. So we better hurry up and let you ask your questions. Go ahead.
Thank you. Mr. Phillips, have you read Mr. Graves' rebuttal testimony?
No, I haven't.
Did Mr. Graves ever?
I'm sorry, I didn't hear the answer.
No, I have not.
Thank you. Go ahead, Mr. Gerhart.
Mr. Phillips, did Mr. Graves consult with you at all in developing his rebuttal testimony?
There were some discussions related to the rebuttal testimony. We were asked to provide a little bit of data. My group was.
Do you know, in your Encompass modeling, do you recall what the smallest amount of gas capacity is in the replacement portfolios with no battery capacity?
Off the top of my head, I do not.
Okay. So just to clarify the consultation between you and Mr. Graves, did Mr. Graves ask your opinion or advice about what resources he should assume replace Four Corners after 2024?
No, he conducted an independent analysis. He had asked my group to provide the general capital cost assumptions, fixed and variable O&M, ELCCs, things of that nature that he would then use to inform his independent analysis.
Thank you. Would you please turn back to your direct testimony to page 6? Please let me know when you're there.
I'm with you.
So on line 7, there's a sentence that begins, "The result is a one-time opportunity that allows PNM to accelerate its exit from FCPP," and the sentence continues on from there. Do you see that?
Yes, I do.
And so I want to make sure I'm understanding what you're saying. When you say the result is a one-time opportunity, I believe you're meaning that PNM's current proposed exit from Four Corners is a one-time opportunity to exit before 2031. Is that what you mean?
In part, I would agree with you. I think the preceding sentence describes it a bit more in detail. The one-time opportunity is the agreement with NTEC, facilitated by PNM's shareholders contributing $75 million to the transaction, which the joint result of those two things is NTEC taking on the obligations associated with the coal supply and operating agreement. If PNM were to remain on the hook for those costs, there's no way for us to provide economic benefit to our customers and get replacement resources.
Thank you. If this application were denied, there is still a possibility that PNM could figure out a way to exit Four Corners before 2031. Would you agree with that?
I would say hypothetically, there's always a possibility. What we have right now is an actual opportunity. One in the hand is better than two in the bush.
Thank you. So I want to follow up with some questions around a conversation you had with Mr. Tisdale around new gas resources and hydrogen conversion. So first, I want to make sure I understand what you did. So you assumed in the 2024 and 2031 exit that PNM's portfolio is carbon-free in 2040, right?
Yes, that's correct.
Okay, so the way you achieve that for gas resources is to convert them all to burning 100% hydrogen after 2040. Is that right?
Kind of. So the distinction I'll draw is the existing gas fleet. There's a number of different gas assets. We assumed an early retirement of all of the existing gas assets. So except for two, Lordsburg and Lalouse. So the Afton facility, the Luna facility,
I'm
the
sorry,
Rio Bravo.
the Afton facility?
The Afton facility, that's AFTON. The Luna facility, that's LUNA. The Rio Bravo facility, that's RIOBRAVO. Those assets were assumed to stop providing capacity and energy at the end of 2039, even though their depreciable life is a little bit beyond that. The Reeves generating station was assumed to come offline at the end of its depreciable life, which is 2031. And the Valencia PPA was assumed to expire May of 2028, consistent with the current PPA terms. So all of those resources would have then had proxies come in at those different times. Any new gas combustion turbine that came on was assumed to convert to 100% hydrogen and incur a conversion cost in 2039. And we expensed that for an assumption to make it conservative. We did not allow it to amortize out beyond the study period, as well as the Lordsburg and the Lalouse facilities were assumed to convert, incurring a similar cost, well, the same exact dollar per kW cost as the new CTs, and burn 100% hydrogen.
I'm sorry, KW cost as the new?
As the new combustion turbines. And burn 100% hydrogen as of January 1, 2040.
Thank you. I want to zero in on what you just referred to as the conversion costs for the new resources. So my question is, what did you include in the conversion cost, and how did you develop those conversion costs?
The conversion costs were essentially the costs that would allow that particular type of turbine to burn on 100% hydrogen fuel. The existing aeroderivative turbines require about $5 million per 40 megawatt turbine to handle the 100% pure hydrogen. So that was the conversion cost. There was still O&M cost, operations and maintenance costs on top of that. The hydrogen fuel then was assumed to be approximately $40 per million BTUs. So the underlying assumption for that is there's some type of hydrogen economy that allows for delivery of hydrogen fuel, and that $40 per MMBTU cost is an all-in cost that would cover the manufacturer's cost to produce hydrogen and deliver it.
Thank you. You're aware that PNM has filed a proposed merger with Avangrid?
I'm aware of the filing, yes.
Okay. And I'm going to ask you about this in relation to your modeling. So I'm not attempting to wade into the issue of the relationship between these two dockets. It's going to relate to a modeling assumption you made. So are you aware that in that docket, Avangrid has committed to strive to have PNM system be carbon-free by 2035, if feasible?
I'm aware of the if feasible piece of 2035, yes.
Did you model either of the scenarios using a 2035 zero carbon date for the entire system?
No, this modeling was conducted just prior to the issuance of our 2020 IRP, which was, January 8th was this filing. January 29th was the IRP filing. The agreement that you're referring to, I don't believe occurred until midsummer.
Okay. Do you have a sense of whether, if you were to run the modeling with the 2035 zero carbon date, all other things equal, how that would affect the new gas resources by bumping up that hydrogen conversion date from 2040 to 2035?
Kind of, maybe. So what we generally saw in the modeling, and I do see the Avangrid Iberdrola merger as a learning experience for hydrogen. They're investing, billions of dollars in hydrogen infrastructure in Europe. I believe it's hydrogen electrolysis with wind farms. Anytime we allow the natural gas combustion turbines to be available in the model, they get picked to various degrees because they do provide such a good form of firm capacity, and they don't have a declining ELCC curve. Even if we were to assume that the carbon-free date was 2035 and we had a corresponding conversion cost and hydrogen fuel cost, then I would expect the turbines to continue to come in. It might be at a slightly lower level, but we still would expect them to come into the portfolio on a least cost basis. Predominantly because of that firm capacity they provide at a low cost. And when they're burning hydrogen, they're only running at, a 1 to 3% capacity factor. You don't use hydrogen to get rid of the next, 5 or 10% of carbon emissions. You use it to get rid of the last, 5% because of, it is an expensive fuel. And so ultimately it acts as, the reliability resource, or the ultra long duration storage if you have on-site storage. So I would fully expect to see those turbines continue to come into the model for a least cost solution.
Thank you. I just have a few remaining questions. When did you first learn that PNM was negotiating with NTEC around exiting Four Corners?
It was early to mid 2020, maybe a little bit before that. I forget when I sat in some very brief discussions. The first, a little bit of modeling that was conducted was a part of some sensitivity cases for the Palo Verde analysis, and I believe those were conducted in the first quarter of 2020. I might have sat in a meeting, in late 2019 and learned of some of the negotiations.
My next question, I don't know whether this precedes your time at PNM, so if it does, you can just answer that. But do you know whether PNM's planning team was involved in the decision to exit San Juan Generating Station prior to that plan being announced?
I believe so. I recall, even in my prior work experience, seeing PNM discussing its evaluations of the San Juan Generating Station. I believe even in the 2014 IRP, I forget if it was in the 2011 IRP. It was certainly discussed in the 2017 IRP. So the planning and resources team was certainly involved in that analysis over time.
In 2020, before this case was filed, did Mr. Falgren ever ask you to analyze a scenario for exiting Four Corners other than the application that is pending here in this case?
No, there was really no need to. Again, if you can't avoid the contractual obligations and you would need to continue paying, I mean, virtually all of the costs of Four Corners are fixed. There's very little variable cost due to the must-take provisions of the coal contract and the joint tenants agreement. So, if you have to continue paying all those costs for a resource that you're not using and then add more costs on.
I'm sorry, if you could start that statement again.
So if you were to have to continue paying the costs of a resource that you're not using, and then on top of it, pay for new resources, it would be impossible for there to be an economic benefit to customers.
Did you ever try to do that analysis you were just describing and use the $75 million, and assume the $75 million shareholder payment that is a part of this pending application?
I was never made aware that the shareholders would, offer that up. They offered that up as a part of this contractual negotiation to facilitate the purchase and sale agreement with NTEC. So no, I did not do that.
Okay. Sorry, just to clarify. So you didn't know of that $75 million shareholder payment until this application was filed, or I'm just trying to understand your answer.
We were made aware of the $75 million shareholder payment as one of the terms and conditions of the purchase and sales agreement, or it was a facilitating payment that would aid in the execution of the purchase and sales agreement.
Okay, this will be my last question. I'm trying to understand when you became aware of that $75 million shareholder payment. Do you have a sense of when you became aware that that was a possibility?
Sometime over the summer of 2020, it was discussed that there might be a shareholder payment. I think the $75 million number wasn't known until pretty close to the transaction being executed.
Thank you very much, Mr. Phillips. Mr. Medeiros, those are all the questions I have.
Thank you, Mr. Gerhardt. Let's see, Mr. Harris, the Water Utility Authority.
Thank you, Mr. Hearing Examiner. My notes that I had made concerning my cross is a bit of a mess now because of the prior witnesses. Okay, good afternoon, Mr. Phillips.
I have you down for 20 minutes, is that right?
That is correct. I doubt if I'll use it, but that is correct.
Okay, thank you. Please proceed.
Good afternoon, Mr. Phillips.
Good afternoon, Mr. Harris.
Okay, I noticed that your direct testimony was filed on January 8th. That's correct?
Yes, sir, that is.
Okay, but your testimony contains a lot of analysis and data. So I presume, and you can confirm it, that a considerable amount of work preceded the filing of that testimony. Is that correct?
Yes, sir, that's correct.
Okay, when was that work performed?
I want to say we generally started performing the analysis in the June or July timeframe of 2020. We were updating our models for the integrated resource plan at that point, and we kind of ran a parallel path with this analysis, culminating the analysis in November and December, just prior to filing the case.
Okay. So would it be safe to assume that some of the data that you relied upon is now a year old?
The load forecast and commodities forecast, I believe, were, as I state in my testimony, prepared around June of 2020.
Okay. Turn to page 5 of your testimony at lines 12 to 14.
I'm there with you.
Okay. You state that the PNM included the Four Corners power plant assets as part of the most cost-effective portfolio through 2031 because at the time there was no clear early exit. And were you referring to the 2017 IRP?
Yes, that's correct.
Okay. And my question is, absent the continued obligations that you referred to, would the Four Corners power plant asset been part of the 2017 most cost-effective portfolio?
I don't know. I wasn't there when that analysis was performed, but similar to the discussion I had just had with Mr. Gerhardt, if there's no way to avoid those obligations and all those costs, the majority of them are fixed, you can't economically continue to pay costs and get replacement costs and save customers money.
Okay. My only question about that was that prudency, to my understanding, is still on the table for the next rate case. And that was, I think, raised as a question mark by the hearing examiner. So I'm not, well, I won't testify. Okay.
So, well, I guess I would say to that, and we heard Mr. Falgren say this as well, if there was some type of write-off, it would actually make the remaining part of the plant that the customers are paying for seem more economic. So it would be tougher to get it out of the portfolio at that point. Now, the specific question around the continued obligations, those fixed O&M costs and coal supply costs, even under a prudence argument, those would still be obligations PNM would be having to make, and they would still be required in order to operate the plant. So I don't know that prudence would necessarily apply to those.
Okay, thank you. I appreciate that answer. Turning to page 11 of your testimony.
I'm there.
Lines 14 to 22.
Okay.
At line 21 to 22, one of the input assumptions included costs for replacement resources. What did you include in those costs?
Costs for replacement resources are discussed later. We had a discussion with Ms. Beatles on page 16, beginning at line 15, and it discusses the development of those costs. Generally, the new resources, depending on their type, would include a capital cost, a fixed operation and maintenance cost, a variable operation and maintenance cost, possibly a fuel cost or charging cost for batteries, fuel for combustion turbines, and then the combustion turbines also had a conversion cost for hydrogen to facilitate the generation of hydrogen produced energy.
Did those costs include site acquisition costs, site preparation, interconnection costs, switch yards, potential need for switch yard, legal costs, admin, or profit if there's a PPA?
I think PNM wouldn't like a profit if there was a PPA, but that just doesn't happen. The costs that were assumed for the capital costs, you could consider to be a overnight cost. And so those do include, some assumptions regarding interconnection, site acquisition, other fees for transmission upgrades and things like that. So I believe all of the costs that you referred to were included, except for a profit portion for any PPAs that would go to PNM.
Well, thank you. I wasn't referring to profit for PNM. I was referring to a profit for the provider, because obviously anybody that would win an RFP bid would have not only included a cost, but would also have a profit as part of their cost.
I would assume that. I don't know exactly how they develop their bids. In particular, the way that we had modeled the replacement power alternatives were kind of a hybrid between utility financing and PPAs, in that they used the utility financing model, but allowed the contemporaneous and accelerated monetization of full tax credits.
I'm sorry, they used the utility financing model
and allowed for the contemporaneous and full monetization of production and investment tax credits, which is something that the utilities cannot do, but PPA providers can.
Okay. Thank you. One of the questions that I had when you were discussing the conversion of new units to hydrogen was whether your cost assumptions were, realistic given the time period when the conversion would be done. That's quite a few years down the road. So how much confidence do you have of making predictions on costs that are potentially 18, 20 years down the road?
I would agree that the further out in time, the harder it is to forecast. The cost to convert the turbines themselves are pretty well known at this point. I think the costs that are a little bit lesser known are the cost for producing hydrogen. So if you're going to assume electrolyzers and on-site storage, that wasn't the assumption that we made, but those would have some uncertainties in them. We made an assumption based on industry literature about an all-in dollar per MMBTU, that's a dollar per million BTU fuel price, that assumed there was some third party who was able to provide a delivered hydrogen fuel, and that fuel price would allow them to recover the necessary costs associated with the manufacturing of that hydrogen fuel and delivery of it. $40 is pretty darn high and leads to, a $300 to $400 per megawatt hour price. So it was a very conservative assumption.
I understand, but were those costs for a time period, maybe 18, 20 years down the road?
Those costs were for 18 to 20 years down the road based on the best industry literature available today.
Okay.
And using a conservative assumption on top of that.
Okay. I also have a question on page 16, lines 17 to 13 regarding the carbon emission price forecast.
Yes, sir.
It's my understanding that this price forecast is included in most analysis. Is that correct?
Can you better state the question for me? What do you mean by most analysis in this forecast?
Well, is just on my recollection of cases in the past that often any analysis would have included this cost. And that aside, is there currently a carbon price?
So to clarify then, you're saying when PNM performs resource planning analyses, does it typically include a carbon price, not specifically the carbon price that was used in this case?
Yes.
Yes, that's correct. And the carbon price that is generally used, there's multiple forecasts, a mid, a low, a high, and they are intended to represent what future carbon price that could be passed on to customers would be, such as a carbon tax or cost of a tax and a cap and trade type system. Currently, there is not a federal carbon tax. The forecast, if we look at exhibit NLP3, does not anticipate a carbon price hitting until 2024. So we'll have to see what the Biden administration does, but I believe that there is some discussion from that administration of a federal carbon tax.
Well, you very aptly described what I was driving at, but every analysis to date that have included some sort of a forecast has been wrong simply because we haven't ever had a carbon price or a cap on that. Isn't that correct?
I would agree with you that we've never had a federal carbon tax. The good thing about the Energy Transition Act is that it almost makes, that type of analysis unneeded, because we have a policy driver that tells us where we need to be at with our carbon emissions, and in particular PNM's more restricted than the other two IOUs in the state due to its taking a financing order in the San Juan case.
Right. Well, it's always been a pet peeve of mine because it's always a projection for something that hasn't happened, and I don't know, how likely it is to occur. But at any rate, that was the basis for my question, why it's included. Okay, at page 18, line 9.
I'm there.
It'll take a few minutes, a minute for me to get there. Okay, here you refer to its last RFP. When were those bids submitted?
At the time of writing this testimony, I was referring to the San Juan generating station RFP. That RFP was issued in 2017 for bids deliverable by 2022.
And so those bids were submitted some 4 years ago.
That's true, but they were submitted for a time frame that was very similar in delivery for the Palo Verde RFP, and then the Four Corners RFP is for 2025. And just kind of looking at a comparison of what's happened in those RFPs, we've had very similar bidders, a number of bidders, very similar amount of megawatts, very similar average pricing. So there's nothing that I did previously that I would be unsure about. I'm quite sure we even see repeat bidders if they weren't the selected winning bidder that we continue to see come up. So I'm very confident the analysis that we did here is going to be representative of the savings that we will see coming out of the replacement case when we file that in a few months from now, in Q1 of 22.
Well, at the time that the bids were submitted, wouldn't a prudent bidder have escalated costs because the delivery was several years down the road?
Given the technology curves for solar and batteries, I bet you they would have de-escalated them, and then there was tax credits to take into effect.
But you don't know for sure?
I can tell you what I'm seeing right now in the RFP that we have that will lead to replacement resources.
I'm sorry, can you start your question? Can you start your answer getting slowed down a little bit?
Yes, sir. I can tell you what I'm seeing in the bids received for the RFP that will be used as the basis for the Four Corners replacements. And they are very much in line with the bids, both in terms of the number of bidders, the amount of megawatts, and average pricing that we saw in the San Juan and Palo Verde RFPs.
So you're saying they did a pretty good job when they submitted their bid back in 2017?
Yes.
Okay, and that there was you're justified in using those prices in your testimony. Okay, that's all the questions I have. Thank you.
Thank you, sir.
Thank you. Thank you, Mr. Harris. Mr. Phillips, Ms. Beatles asked you were talking to her about 8-Minute Solar energy company. And you were talking about industry, that's my note on industry-wide problems, supply chain related problems related to COVID-19 epidemic. But interestingly, you said that, I think, I may have mistaken you, but that the 8-minute energy developer, that the problems there are not related to supply chain issues. Is that your testimony?
Yes, sir. My understanding from discussions with Mr. Falgren is that the problem with that project was not related to supply chain issues.
What are they related to?
Can I ask my attorney if we think this gets into confidential discussions? Or Debria, what?
Yeah, hearing examiner, I'm not sure that this is information that we can share at this time. If there's a protective agreement with them, I would have to talk with Mr. German before I.
Well, that was a hanging chat of an answer, not related to. It almost begs asking the question. So I'll back off to the extent that it does get into commercially sensitive territory, but it was definitely left hanging out there. As there's another metaphor for it, a hanging thread, but we'll come back to that. I just saw that. Another thing I asked very quickly, I asked Mr. Falgren about the company's evolving philosophy, or at least perceptible shift in focus on reliability related to energy storage. Do you recall that discussion?
Yes, sir, I do.
Am I wrong, or has there been somewhat of a shift based on the company's experience, let's say, to give you that much?
I think the company is getting more comfortable. We had some concerns, as Mr. Falgren articulated. As I say early in my testimony, we can view resource adequacy as mostly technology agnostic. We have to ensure that we have sufficient amounts of whatever technology type is going to be required in order to operate a safe and reliable system. There are attributes of combustion turbines that are different from attributes of storage, and so you may need a lot more storage in order to operate a safe and reliable system, and that could come with a price tag. But so long as you have the adequate capacity and durational amounts of stored energy, you can operate a safe and reliable
Sorry, so
system.
long as you had the adequate
Capacity and durational amounts of stored energy, you can operate a safe and reliable system.
And at scale, that would look like something like, say, Moss Landing.
I'm less familiar than Mr. Falgren with Moss Landing. I know that they have a lot of storage there. I think the key is that it's not just total megawatts, but you also have to have enough megawatt hours of the storage as well. If you think about a Texas type event, you might need days worth of storage.
But it would be part of the solution, wouldn't it?
Yes, sir, it would.
Now, I'm going to stop on Moss Landing, but I was hoping you were part of the team that he sent out there to review that facility. But apparently you were not.
I was not.
Oh, bummer for you. But no, because of obviously where it's located, not necessarily the facility itself, but being on Monterey Bay. So Monterey Bay.
Thank you.
So I'll leave it at that. Mr. Williger, do you have any redirect?
Yes, I just have one substantive question after I kind of get into the set Mr. Phillips up for this. So it should be quick because I know you have a 2 o'clock hard stop. Mr. Phillips, you recall some discussions with various attorneys regarding the RFP that PNM has conducted for replacement resources for the Four Corners plant. Is that correct? Do you remember that?
Yes, I do.
And you also had a discussion with Ms. Beatles about whether that RFP will result in adequate replacement resources for Four Corners. Do you recall? Okay. Is there anything you can tell me about the robustness of the RFP that confirms some of the information or the proxy replacement portfolio that you modeled in your testimony?
Sure. The RFP response has been very robust. We're seeing very similar numbers of bidders as we saw in the Palo Verde and San Juan replacement portfolio RFPs. Very similar in terms of the average pricing. We have a lot longer of a lead time for this procurement, so we expect the supply chain issues to be mitigated by then. We're a lot of repeat bidders, bidders who might have been the ones who were right next to the selected bidders in previous RFPs are resubmitting, projects that were very cost competitive. Seeing a large number of different types of bids. We're seeing, solar storage, solar plus storage hybrids, wind, gas turbines. We're seeing a lot of megawatts. We're seeing a lot of very cost competitive bids. Again, average pricing in the same realm as the previous RFPs. We have, as part of one of the instructions to bidders, that they will need to hold those prices and those bids good through April 2023. So, looking back through what was assumed in the analysis and put together for the proxy replacement portfolio, I'm very confident that we will come together with a case that has resources coming online as expected and preserves those customer savings in the range that I estimated.
Examiner, that's all my redirect. Thank you.
Thank you, Mr. Williger. Mr. Phillips, thank you so much for your testimony as always. You are excused.
Thank you, sir.
Thank you. Yes, ma'am.
Yes, I just have one thing for tomorrow in terms of scheduling for witnesses. Mr. Atkins does need to go tomorrow. So I don't know if you would like to change up the order, put him first.
You anticipated where I was going next, Mr. Williger. What I was going to suggest is that we keep, since they're East Coasters, I assume, both Ms. Crane will be testifying from Eastern time zone. Is that right?
Yes.
Mr. Elliott's not, and Mr. Atkins as well?
I'm not sure where he is now. I know he's been in California and Texas recently, so I'm not sure.
Could be anywhere in the world. It could even be on Monterey Bay.
Yes.
It's where I'd like to be. But in any event, I propose that we take Ms. Crane and Mr. Atkins first, and then we slot in, following that, Mr. Baker and Mr. Setledge, and call that a week. How does that sound?
Sounds good.
I'm sorry, who said that?
That was
The hearing
Mr. Elliott.
examiner.
Hold on. It was Mr. Elliott who just spoke, and then I was going to ask Ms. Terwilliger if that sounded okay, since it's
Yes,
her
sir.
witnesses.
Yes, sir. Mr. Atkins, followed up by Mr. Setledge and Mr. Baker is good. Thank you.
Yeah, the order I have is Crane, Atkins, Baker, Setledge. But is that okay?
Yes. Sorry.
Okay. Mr. Albright, did you have something?
No, sir. I just was going to ask you to repeat the order. So thank you for doing that.
Okay. Is there anything else before we break for today? Thank you all.
Can I ask?
Yes, ma'am.
This is Mary Lanassi. I just wanted to tell you in advance, I would like to, and for my 15 minutes for Mr. Baker, could I please only have 5, and can I move the 10 minutes to Mr. Graves?
Yes, let me fix this now. To follow you on it. So you said on Baker, Ms. Nanazi, you want to do what?
I have 15 minutes right now, and I would like to please just have 5 and move 10 more to Graves. So that would give me 45 on Graves.
Any objection to that? I have made that change in my master tally here.
Thank you so much, sir.
Thank you. Regarding that, Mr. Elliott, have you decided what to do? Because right now I have you with 25.5 minutes with Mr. Graves and 25.5 minutes for Ms. Eden. Have you decided yet?
If I need to reduce my time further?
Or, well, that's what when I took the time that you didn't use with other witnesses, I allotted it equally to those two witnesses, and I have 25.5 minutes each left. So you have 50 minutes of cross-examination time total, fungibly.
That tracks with my numbers as well. So if I can leave it that way, that would be ideal.
Of course, just
Okay.
revisiting. Just
Thank you very much.
You're welcome. Anybody want to address those issues? Any of those kinds of issues like Ms. Nanazi and I just did with Mr. Elliott? Okay, if there's nothing else, then we're going to recess for today. And I will see you all tomorrow morning at 9 a.m. Thank you all very much. I appreciate the accommodation again. Okay, we're in recess until 9 a.m. tomorrow morning.